Thanks, Millie. Can you commence the recording, please?
Well, good afternoon, everyone. It's now 2 o'clock. The inquiry is now resumed. I assume that everyone can hear me. Yep, thank you very much indeed. At this stage, and I think it's probably protocol that all we need in terms of cameras is advocates for the main parties who are speaking today to leave their cameras on. Everybody else can turn their cameras off. It may seem a bit strenuous that includes you as well, Ms. Kirby-Hawkes. I think you need to leave yours on as well. It may appear a little bit strenuous that you have to have your cameras on throughout the course of this afternoon, but I think it's only fair for the purpose of the recording that people see the final phase of the inquiry in terms of the advocate's presence. So just to remind everyone that my name is Stephen Normington. I'm the inspector who's been appointed by the Secretary of State to hold this inquiry into an appeal made by Cemix Operations Limited. The appeal relates to the refusal of a plan application by Hampshire County Council for the proposed extraction of sand and gravel with restoration to grazing land and recreation using imported inert restoration materials, the erection of associated plant infrastructure and the creation of a new footpath and access onto Hamble Lane. And the appeal site is located at former Hamble Airfield, Hamble Lane, Hamble Lurice, Hampshire. Just in terms of today is the very last session of this inquiry. It's the closing session. So in a moment, for the purpose of those who's observing online, we will hear closing submissions from the council, then the Rule 6 party, and then the appellant. Following that, I will have a very brief discussion about next steps and just to reiterate further discussions on any costs that we touched upon at the last session a few weeks ago. And then we'll close as far as any further oral submissions are required, and I'll identify the written submissions that I will require, and then I'll identify when I will be closing this inquiry in writing. Just a couple of housekeeping things before we start. Just to explain some of the inquiry documents that I've received since I think it was last week actually that we last sat together, or the week before last, I can't remember because there are lots of things been happening. But as far as my notes go, when we concluded our last session, my last inquiry document number was number 71, which was a speaking note of Proud Baines. So since then, I'll just go through a couple of inquiry notes, then we can just see if there's any other housekeeping matters. I've had the appellant's note on the highway mitigation measures cost. That's inquiry document 72. I have the Rule 6 parties note on the highway mitigation costs, which is inquiry document 73. I have a draft version of the unilateral undertaking that was submitted this week, which is inquiry document 74. I've now received closing submissions from all parties in this appeal. So 75 is the closing submissions on behalf of the council. 76 is the closing submissions on behalf of the Rule 6 party. 77 is the closing submissions on behalf of the appellant. Next week, there will be some further correspondence on the UU, which I'll identify again at the end of our discussions today. But 78, inquiry document 78, will be the track changes version of the UU containing the Rule 6 parties comments and the appellant's response to those Rule 6 parties comments. I think we already have some of those, which I've received today. But it would be helpful to me if we could have a UU that just shows the track changes, how the comments where necessary have been taken on board, made by the Rule 6 party. So that will be 78. 79, which will be the final version of the unilateral undertaking, and 80 should be the very last document that's required to be submitted, which will be the SIL compliance statement. That, I think, should take us completely up to date in terms of what we have and what is anticipated to be coming in by the end of next week. Just to check with the council, Ms. Kirby-Hawkes, is that your understanding of where we're at in terms of inquiry documents?
That's correct, sir, yes.
Okay. I'm going to go around the room in the usual order to see if there's any housekeeping matters. I will start with the council because you're there. Any matters of housekeeping that I need to be aware about of Ms. Kirby-Hawkes beyond those matters that I've referred to?
Nothing further, sir, no.
And Mr. Fulbrook, anything from your perspective?
No, thank you, sir.
Thank you very much, Mr. Fulbrook. And Mr. Strachan, thank you for reorganising your whatever it was, your other matters, inquiry matters or examination matters to be present today, which is, I think, is very important for the purpose of this inquiry. Any matters from the appellant in terms of housekeeping?
No, sir, thank you very much. I don't think I've got the closings as yet of the council or the Rule 6 party. I suspect they don't have mine, but I just thought I'd say it would be very helpful in order to follow them if a copy could be provided.
What I will ask Mr. Legg's present in today's meeting, I'll ask Mr. Legg if he could send you a copy of the council's and the Rule 6 parties closing submissions. They have been sent, so I have a copy of them. So I'm sure Mr. Legg will send you one of those straight away.
Thank you. Could we, and as you indicated, after closings, could we just come back to the question of timetable for final documentation? But I probably best deal with that later if that's
no problem. Okay, for people who's observing today, there will be no interruptions in terms of the closing submissions. There'll be no questions, no interruptions from me. The closing submissions will be made available on the inquiry website, so people will be able to read exactly what the advocates are saying this afternoon. It is, in that sense, it's an observation of those closing submissions as they're being read out. We can hear them, and some people, such as myself, will be able to read them as we go through today. So that's what will happen. There will be no interaction by any of the parties other than the advocates on the line. So everyone else will be required to turn their cameras off and remain off at all times and the microphones silent. Okay, I don't think there's anything else that I need to say in terms of any other procedural matters. I think all that does remain me to say now is to ask Ms. Kirby-Hawkes on behalf of the council if you can provide closing submissions, which I understand have been prepared by your advocate, Mr. Lewis.
That's correct, sir. Thank you very much. Yes, so my name is Lisa Kirby-Hawkes. I'm the Head of Development Management at Hampshire County Council. I will be delivering the closing submissions for the County Council on behalf of Gwion Lewis KC. These closing submissions are shorter than they would not usually be, given that this inquiry has been mainly concerned with the matters in dispute between the appellant and the Rule 6 party. As the County Council confirmed in its opening submissions, it is no longer resisting the appeal. As Minerals and Waste Planning Authority, having considered additional information provided by the appellant and the local highway authority since the appeal was made. The County Council recognises the concerns raised by the local community in relation to the planning application and the appeal. The County Council also acknowledges that many who live in the vicinity of the site considered that it should have stuck to the reasons it gave for initially refusing planning permission and sought to defend them at this inquiry. However, all parties to the planning appeal proceedings are subject to an ongoing duty to review the merits of their cases, particularly in light of any additional information or evidence provided by other parties during the appeal. A party that fails to do what would be at risk of having to pay another party's appeal costs, as it's generally unreasonable to refuse to engage with new information or evidence that could resolve areas of disagreement between parties. In its planning practice guidance on appeals, the UK government gives us one example of the type of behaviour that may give rise to a substantive award against a local planning authority in paragraph 49 as not reviewing their case promptly following the lodging of an appeal against refusal of planning permission or non-determination, or an application to remove or vary one or more conditions as part of a sensible ongoing case management. The County Council could not ignore this advice. Failing to act in accordance with the guidance after receiving additional information from the appellant and the local highway authority would have put the County Council at great risk of being ordered to pay this appellant's substantial appeal costs out of public funds, a position in which no responsible public body should find itself. What, therefore, was the County Council's case in its original reasons for refusal that it needed to keep under review? It's important to be clear about what was and what was not within the scope of these reasons as articulated by the County Council's Regulatory Committee. Contrary to the assumption made by some third parties in their representations at the inquiry, none of the Regulatory Committee's reasons for refusal took issue with the principle of allowing a mineral extraction use on the site. It would have been unreasonable for the Regulatory Committee to reject the principle of mineral extraction use on the site when the site is allocated for mineral extraction in the adopted Hampshire Minerals and Waste Plan 2013. As we have heard at the inquiry, the site is also allocated for mineral extraction in the emerging partial update to that Minerals and Waste Plan, now at an advanced stage of preparation after examination hearings took place in February 2025. The County Council acknowledges that many local residents are still aggrieved by the allocation of the site for a mineral extraction use in the extant Hampshire Minerals and Waste Plan. However, in our plan-led system, development plan documents such as the extant Minerals and Waste Plan can only be formally adopted by the planning authority after they have been examined by an independent inspector at public hearings and judged to be sound. To be considered sound, a draft plan and the site allocations within it must be, amongst other matters, justified in the sense of being an appropriate strategy based on proportionate evidence and effective in the sense of being deliverable. These national planning policy tests applied when the Hampshire Minerals and Waste Plan 2013 was adopted and still apply here today. See paragraph 36 of the current national planning policy framework. The Hampshire Minerals and Waste Plan 2013 could not have been adopted, therefore, unless an independent inspector agreed with the County Council and its plan-making partners at the time that a mineral extraction use on the site was realistic and deliverable. The adoption of the Minerals and Waste Plan 2013 thus established the acceptability, in principle, of a mineral extraction use on the site. There was no legal challenge to the site allocation after the Hampshire Minerals and Waste Plan was adopted. Against this background, it would have been unreasonable, indeed unacceptable, for the County Council's Regulatory Committee to take issue with the principle of mineral extraction use on the site. This is precisely why the Regulatory Committee opened all three of its reasons for refusal with the words, on the basis of the information submitted, or on the basis of information before the Minerals and Waste Planning Authority. These formulations signalled the possibility that the submission of further information or evidence from the applicant, either as part of a further planning application or potentially an appeal, could resolve the concerns raised in relation to flood risk, the impact on the highway network, and the effects of air quality, respectively. In the event, this is what happened. First, the appellant's submission of a revised post-restoration drainage scheme, supported by a technical note and relevant plans, satisfied the County Council as lead local flood authority, LLFA, that it is no longer needed to maintain a holding objection to the proposal due to its concerns about off-site flood risk post-restoration. As the Regulatory Committee's first reason for refusal was predicated on this holding objection from the LLFA, it would have been unreasonable for the County Council to maintain this reason for refusal when the holding objection was no longer in place. Second, the appellant, in cooperation with the County Council as local highway authority, prepared additional information about the financial contribution of £500,000 offered by the appellant for a scheme to improve active travel measures in the vicinity of the site. This was in response to the Regulatory Committee's second reason for refusal, the basis of which was the committee's judgment that it did not have enough information about the £500,000 contribution offered to enable it to conclude that it had complied with the statutory tests in Regulation 122, Part 2 of the Community Infrastructure Levy Regulations 2010, the CIL Regulations 2010. When the appellant and the local highway authority then duly provided additional information, including examples of the typical costs of other highway works in the county, which gave the Minerals and Waste Planning Authority a better sense of whether the £500,000 offered was likely to be sufficient for the works proposed, the Minerals and Waste Planning Authority could not ignore that information. Instead, it had to consider whether it would be reasonable to maintain the second reason for refusal, having been presented with this additional information, and when the sufficiency of information provided in support of the financial contribution is a matter of planning judgment, not something that can be measured by an objective standard. The Minerals and Waste Planning Authority considers that it was right to press the appellant and the local highway authority for more information about this financial contribution, and also right to review the position responsibly when more information was provided. The Minerals and Waste Planning Authority notes that even more information has now been provided by the appellant and the local highway authority in relation to the £500,000 contribution towards the end of the inquiry in response to the matters raised by the Rule 6 party. Suffice to note that the Minerals and Waste Planning Authority regards this further information as confirming that it was right to accept the necessity and reasonableness of the £500,000 contribution when it did. As for the Regulatory Committee's third reason for refusal, this was based on an unexpected late objection by Natural England to aspects of the Habitats Regulation Assessment, HRA, undertaken by the County Council as competent authority on the proposal. When Natural England subsequently revised its opinion and concluded that the impacts of the proposal on air quality had, in fact, been adequately addressed within the HRA, and that securing the mitigation measures considered in that HRA would be sufficient to enable an adverse effect on the integrity of designated sites to be ruled out, the basis of the Regulatory Committee's third reason for refusal fell away. Again, it would have been illogical and unreasonable for the County Council to maintain the third reason for refusal in these circumstances. Accordingly, as the appeal progressed, the County Council found itself in the position that all three of the Regulatory Committee's reasons for refusal had been adequately addressed by the provision of additional information by the appellant and the local highway authority. It would not have been unreasonable for the County Council to persist with any of these reasons in these circumstances. That might have been the more expedient option in the short term, given the local opposition to the proposal, but it was not an option that was reasonably open to the Minerals and Waste Planning Authority as a responsible public body that was required to keep the merits of the case under review. Moreover, whilst some third parties expressed the view that the County Council's Regulatory Committee should have been convened again ahead of the inquiry to vote formally on whether its reasons for refusal should be maintained or withdrawn, there was no requirement for such a meeting in the County Council's constitution. In any event, as Ms Lisa Kirby-Hawkes, the County Council's Head of Development Management and Flood and Water Management, explained in her evidence at the inquiry, officers did keep the chairman of the Regulatory Committee informed about the additional information provided by the appellant during the appeal and the officer's response to it. The logical consequence of the Regulatory Committee's reasons for refusal being addressed is that the County Council, as Minerals and Waste Planning Authority, no longer advances a basis in planning policy for dismissing the appeal, provided the adequate ecological mitigation is secured, as discussed further below. So we're moving on just to a section about the clause 14.6 of the appellant's unilateral undertaking. There is one brief outstanding matter relating to clause 14.6 of the appellant's unilateral undertaking. It's the appellant's insistence of the inclusion of this clause that has led to an offer of a unilateral undertaking rather than a bilateral Section 106 agreement, as the County Council was not content for clause 14.6 to be included in the bilateral agreement, even with the protection of a so-called blue pencil clause, enabling the inspector to disapply the clause in his decision if he considers that it does not meet the tests of Regulation 122 Part 2 of the Steel Regulations 2010. In general, the County Council was only content to agree to the blue line pencil approach when there was at least a legitimate argument that to be made on both sides as to whether the obligation complies with Regulation 122 Part 2 tests. That is not the case in relation to clause 14.6, which is not even an obligation in the sense of a legal obligation entered into to mitigate the impacts of the development proposal in accordance with PPG on planning obligations paragraph 001. Rather, it is a clause that seeks to disapply necessary obligations in Schedules 1 to 5 of the unilateral undertaking relating to ecological mitigation and the management plan in certain defined circumstances. Clause 14.6 reads, in the event that A, a new planning permission is granted, and B, the new planning permission is implemented by the carrying out of a material operation as defined in section 56 part 4 of the Act, the obligations in schedules 1, 2, 3, 4 and 5 of this deed shall cease and determine insofar as they apply to the site or that part of the site to which the new planning permission relates. The new planning permission is defined in section 1 of the unilateral undertaking as a planning permission granted for the development of the site or a part thereof by either the County Council or Eastleigh Borough Council as the responsible local planning authority or their respective successors for any alternative uses. Sorry, just bear with me. The appellant invites the inspector to reach a conclusion in his decision as to whether this clause complies with the tests in Regulation 122 Part 2 of the SIL Regulations 2010. Should the inspector conclude that it does not comply with one or more of these tests, the appellant accepts that clause 14.6 will cease to have effect pursuant to the provisions in a subsequent section of the undertaking entitled SIL Regulations. The section numbering as AY in the draft of the unit of the undertaking that has been provided to the council at the time of writing these closing submissions, but the intended effect of the clauses in the section SIL regulations was clear. There is a short answer to this invitation, which is that clause 14.6 relating to the hypothetical future planning permissions granted in relation to the site for an alternative use is simply not necessary to make the current appeal proposal acceptable in planning terms, nor is a clause relating to the hypothetical future planning permission for an alternative use directly related to the current appeal proposal, or fairly and reasonably related in scale and kind to the current appeal proposal. Any planning obligations that must be attached to any planning permission granted in the future for an alternative use, including any changes needed to planning obligations previously entered into in relation to the site, could only be properly considered if and when any application is made for such an alternative use in the future. They are not matters to be considered now, and it is certainly not necessary to consider them now before any application for alternative uses has ever been made. The County Council therefore submits that the inspector should respond to the appellant's invitation by concluding in his decision that clause 14.6 does not meet any of the tests in the SIL regulations section of the undertaking and therefore ceases to have effect pursuant to the provisions of that section. For completeness, should the inspector conclude, contrary to the submissions above, that clause 14.6 should have effect within the unilateral undertaking, this would have a significant implication for the County Council's case on the planning balance in this appeal, as clause 14.6 would raise serious doubts about the delivery of ecological mitigation that the County Council considers necessary to make the appellant's proposal acceptable in planning terms. As the County Council has explained in its evidence to the inquiry, it is satisfied that the ecological impact of the proposals can be mitigated by the submission and approval of an ecological mitigation and a management plan, an EMP, and the delivery of the measures in the EMP for a 30-year period from the conclusion of the aftercare stage for all phases of the proposal. Provision is made for the EMP in Schedules 1 to 5 of the unilateral undertaking. As drafted, clause 14.6 would result in the release, in whole or in part, of the EMP obligations before the necessary period of 30 years had concluded. Simply, in the event of a new planning permission being granted for an alternative use on the site and then implemented, which could mean no more than digging a narrow trench. This outcome would be completely unacceptable to the County Council. As submitted above, the appropriate time to consider any implications for the EMP obligations for any planning application made in the future for an alternative use would be after any such planning application is made. It is not only unnecessary, but illogical to seek and to make provision preemptively for this hypothetical scenario now. The County Council's conclusion that the proposal complies with Policy 3, which is the protection of habitats and species of the Hampshire Minerals and Waste Plan 2013, is contingent on having assurance that the appellant's ecological obligations will be in place for the period required to achieve the necessary mitigation. If this assurance falls away because the inspector concludes that the clause 14.6 of the unilateral undertaking complies with the tests of Regulation 122 Part 2 of the SIL Regulations 2010, the Council will consider the proposal to be in breach of Policy 3 of the Hampshire Minerals and Waste Plan. It is unfortunate that clause 14.6 of the unilateral undertaking has muddied the waters at a late stage in the inquiry. It does not appear that the appellant has properly thought through the potential implications of this odd clause. This serves only to reinforce the County Council's case that the clause is not necessary to make the current proposal acceptable in planning terms and should therefore cease to have an effect in accordance with the conclusion by the inspector to that end. So that's from Gwion Lewis Casey of Black Map Chambers. Thank you, sir. You're on mute, sir.
Sorry, sir.
That's my fault, and I thought I clicked the button, but clearly I hadn't. But thank you for those submissions on behalf of the council, Ms. Kirby-Hawkes. Obviously, they are the written submissions of Mr. Lewis and delivered verbally on his behalf. So those should now be available at some point this afternoon on the council's website. I'm sure we'll come back to we'll be coming back to the UU at the end of closing submissions today. At that point, there's nothing more for me to say. Can I invite Mr. Fulbrook on behalf of the Rule 6 party to commence closing submissions, please?
Yes, thank you, sir. The strength of local opposition to the proposed development is abundantly clear from the hours of articulate and passionate representations that this inquiry has heard, and the more than 5,000 objections from the whole spectrum of people and interests in the local community, from business owners and residents to school children and teachers. The appellant will no doubt seek to suggest that this opposition is based on ignorance about the full nature of its scheme and an inherent hostility towards development. This is certainly not the view of the HPDG, which, as I explained in opening, is a partnership between Hamble Parish Council and the Hamble Peninsula Residents Group. It's the HPDG's group that the local residents and interested parties, many of whom have relevant expertise in their own right, have consistently articulated well-founded concerns about the effects of the proposed development, which are based on their own intimate local knowledge. Now, as I also explained in opening, the HPDG has not presented evidence on all of the points raised by the interested parties to this inquiry. The HPDG does not have the resources to take every point, and nor would it be proportionate for it to do so. It's mindful of its responsibilities as a Rule 6 party and has sought to focus its case on areas which it considers would benefit most from the formal testing of evidence in the inquiry format, and in respect of which it has obtained expert evidence to support its position. However, the HPDG as a group is absolutely clear that this should not diminish the weight given to the representations of interested parties. Rather, they reflect the extremely challenging nature of this site. This site is highly valued by the local community, which has used it as an informal recreation space for many years. And as you will have observed at the site visit, it's a long way from the inaccessible overgrown space that the appellant has suggested it to be. It is an attractive and popular space. Indeed, the Minerals and Waste Plan not only acknowledges this, but specifically lists the desire to maintain and manage existing informal recreational use as a development consideration in respect of this site's allocation. The site's location also presents a number of challenges which themselves help to explain the extent of opposition to the proposed development, and this is well illustrated by figure 2.3 to Mr. Whittingham's proof of evidence, which I include. This shows that the site is sandwiched between two schools with about 1,600 pupils, a railway station, an early years centre and several bus stops serving the local community. It's also surrounded to the south and to the south and east and much of the west by residential development up towards the boundary. There are business parks and marinas close to the site. Access to the site is to be provided from Hamble Lane, which is already formally acknowledged by the local planning authority in 2022 to be suffering from serious congestion, as a result of which the County Highway Authority, which has effectively imposed and maintained a moratorium on further development along it. Representations made by the UK Health and Security Agency during the application process indicate that this is very much an atypical site for a quarry. Such interventions are rare for the UK HSA and should be given great weight. It is, of course, important to acknowledge that the site is allocated for the extraction of sand and gravel in the plan. However, it should go without saying, and indeed Ms Pearman for the appellant accepted, that an allocation is not a guarantee of planning permission, and the allocation itself identifies a number of development considerations which mirror the concerns being raised by the HPDG and numerous others. And so I turn to a summary of the case for the HPDG. Turning now to the specific case being made by the HPDG, it's their position that planning permission should be refused for the following reasons. First, there remains reasonable scientific doubt that the proposed development will have no adverse effect on the integrity of European sites by reason of 1, the hydrological impacts of the proposed development during the operational phase of gravel extraction and in the final proposed state, and or the displacement of informal recreational use of the site, which will arise as a direct consequence of the proposed development. And then second, the traffic impacts of the proposed development will have an unacceptable impact on highway safety and or a severe impact on the road network, taking into account all reasonable future scenarios. The mitigation proposed is not sufficient to overcome these impacts. These submissions deal with these issues in the order in which the evidences inquiry was heard and conclude with submissions on the planning balance, including any weight that can be given to the need for this development. But before turning to those matters, it's necessary to deal up front with an issue which arose in the final few minutes of the last inquiry session, namely the abandonment of the Section 106 agreement in favour of a unilateral undertaking. The reason for this frankly astonishing last-minute development appears to be the insistence of the landowner, a house builder, that a clause be inserted which removes all obligations relating to ecological mitigation, biodiversity net gain, in the event that any new planning permission is granted. We say this creates a significant lacuna. It means that there cannot be any guarantee that the ecological mitigation and enhancement deemed necessary to make this development acceptable, as you've just heard, will actually be delivered. Any new planning application would have to be determined on its own merits, and it's unclear whether the current state of the site as it is now, or the requirements of the UU would or even could be taken into account. It follows this that the UU, if this clause is deemed to be effective, should not be given any weight, and this would be fatal to this appeal. It's notable that even after disappointingly caving in on every other point, the Minerals and Waste Planning Authority absolutely refuses to accept this amendment. This, we say, is telling. It's also unacceptable that such a significant change should have been thrust upon the parties at such short notice. So now I turn to the adverse effect on the integrity of European sites and deal briefly with some legal principles. The requirements of the Conservation of Species and Habitats Regulations 2017 are largely summarised in the judgment of the Court of Appeal in Wyatt. And some points are as follows. A competent authority may not grant planning permission for any development which, unless it has ascertained that it will not adversely affect the integrity of a European site, save where there are imperative reasons of overarching public interest. And then an appropriate assessment must ascertain that there will be no adverse effect on the integrity of European sites beyond reasonable scientific doubt. The assessment must be based upon the best scientific evidence in the field. It cannot have lacunae, and it must contain complete, precise and definitive findings capable of removing all reasonable scientific doubt as to the effect of the works proposed on European sites. This embodies a precautionary approach. There was some debate during the inquiry about some of the relevant legal principles. First, there was some suggestion that the requirements of the habitats regulations were somehow less stringent in relation to effects which have been screened out prior to appropriate assessment. To the extent that this suggestion is maintained, it is wrong. Of course, where a competent authority is satisfied that an effect can be screened out because it will not have a likely significant effect on the integrity of European sites, it's not necessary to carry out an appropriate assessment of that effect. But it does not follow that the decision to screen out an effect must not also meet the standard of no reasonable scientific doubt or be based on the best available evidence in the field. This would be perverse. It would entirely undermine the stringent requirements that the courts have placed on those carrying out appropriate assessments. In the end, all roads, screening and appropriate assessment lead to the same destination. You cannot grant planning permission unless you are satisfied beyond reasonable scientific doubt that there will be no adverse effect on the integrity of a European site. Second, there was a suggestion that the HPDG has neglected the law relating to the weight that should be given to the views of statutory consultees, and particularly Natural England. Reference was made to paragraph 9(4) of the Wyatt judgment, which explains in summary that significant weight should be given to the advice of Natural England and that a competent authority must have cogent reasons for departing from or disagreeing with that advice. The HPDG has neither neglected nor failed to acknowledge this principle. Indeed, it was expressly addressed in Mr. Andrews' proof of evidence. However, what the HPDG would stress is that you, sir, must reach your own view, and you are entirely at liberty to disagree with Natural England. And this was accepted by Mr. De La Haye for the appellant, who conceded that when considering and weighing up Natural England's advice, it will be relevant and necessary to consider what information that advice was based on, to consider the level of reasoning provided by Natural England, and to note the fact that you, sir, have the benefit of hearing live evidence, which was not before Natural England. Third and finally, Mr. De La Haye, on behalf of the appellant, accepted that it is not being asserted that there are imperative reasons of overriding public interest which could justify this proposed development. So the question for you, sir, therefore, is whether you can be satisfied beyond reasonable scientific doubt that the proposed development will not have adverse effect on the integrity of European sites. If such a doubt exists, then this appeal must be dismissed. Full stop. Mr. De La Haye accepted that the appellant bears the burden of meeting this very exacting evidential threshold. It is not for the HPDG to prove that an adverse effect will arise, merely to raise reasonable scientific doubt. And to this end, the HPDG has obtained evidence from two professional experts who have made clear that between them, they do hold scientific doubt relating to the hydrological and recreational impacts of the proposed development. So if you agree that those doubts are reasonable, then that is the end of this matter. And now take the hydrology issue. So by hydrology, these submissions refer to the potential for the proposed development to cause adverse effects arising from changes to the rates of flow in groundwater-fed streams, which discharge into Southampton Water to the west of the site and the River Hamble to the east. Between them, these water bodies are part of the Solent and Dorset Coast SPA and the combined Solent and Southampton Water SPA, Ramsar, and Solent Maritime SAC. These are the European sites which are at issue in this appeal. These streams have been identified and charted by Dr. Clothier on behalf of the HPDG. He supplied a plan showing them at figure 6 of his proof, which I reproduce below for convenience. Dr. Dewhurst for the appellant did not dispute the existence of the streams, and indeed, sir, you will have been able to view at least some of them on the site visit. Dr. Clothier has appended a photographic record of the streams to his proof. The essential premise of the HPDG's argument in relation to hydrology is as follows. Dr. Clothier's evidence is that the river terrace deposits and sand and gravel currently in place on the site act as an aquifer which stores rainwater, allowing it to gradually discharge into the streams. This sustains flows into the streams potentially for weeks or months after rainfall. This effect was referred to in evidence as a shallow hydrograph, a relatively slow flow rate over a long duration. During the operation and restoration of the site, the river terrace deposits will be removed and replaced by inert infill. This will not store water in the same way, meaning that it will discharge into the streams at a much faster rate, a day or two. This effect was referred to as a steep hydrograph, a relatively high flow rate over a short duration. Groundwater may also be directed to different streams than previously. Mr. Andrews' evidence is that the change from a shallow to a steep hydrograph could adversely affect habitats and species, which depend directly or indirectly on the existing hydrology, that is the sustained freshwater flow, water quality and salinity in the areas where the streams flow into the European sites, due to the loss of the sustained flow or changes in the rate of flow of fresh water into the European sites. There are therefore two elements to the HPDG's case on hydrology, and each of these is unpacked in more detail as follows. The first then is the effect of the proposed development on the hydrograph. There was no dispute that the site is made up of river terrace deposits which overlie solid strata. The solid strata is comprised of a mixture of Celsey-Ernley sand formation and March farm formation. For his part, Dr. Clothier produced a conceptual site model which provides a visual illustration of how the river terrace deposits act as an aquifer and how rainwater falling into them feeds into the streams. Dr. Dewhurst was at pains to criticise the conceptual site model on the basis that it described the barrier between the RTD and the solid strata as an aquiclude. It was suggested that since an aquiclude is generally understood to be a geological formation which is practically impermeable to water, Dr. Clothier had overlooked the fact that the solid strata was also an aquifer and that there was evidence to suggest that it too played a role in the storage and discharge of rainwater. However, Dr. Clothier plainly did not overlook this. His proof of evidence acknowledges that infiltration into the solid strata is possible, but at a much slower rate. This, of course, must be correct because, as was put to Dr. Dewhurst, the infiltration rates for RTD are orders of magnitude up to 100 times higher than the solid strata. Any suggestion that, therefore, that Dr. Clothier's evidence is in any respect undermined by the use of the word aquiclude is nothing short of fanciful. In the end, Dr. Dewhurst accepted that the RTD does act as a reservoir which stores rainwater and discharges it into the springs. This is supported by borehole data which shows substantial groundwater being stored in the river terrace deposits even in April, the median month. Flow rates of water through the RTD to the streams will vary, but on Dr. Dewhurst's own evidence it can take up to a year for water falling at the centre of the site to emerge in the streams at the edge of the RTD. Accordingly, Dr. Dewhurst accepted that the RTD plays a role in sustaining stream flows. In other words, it contributes to the shallow hydrograph identified by Dr. Clothier. This is borne out by Dr. Clothier's observations in February 2023, where most of the streams were seen to be flowing strongly even after weeks of limited rainfall, and by the observations of a local landowner who reported that water in Stream 6 flows well into the late spring and summer months. So you will have also been able to view the streams flowing on the site visit in April after many weeks of limited rainfall. Dr. Dewhurst conceded that she had no basis for doubting these observations. And this is because, despite the hydrological connectivity between the site and the European sites having been identified as a concern during the examination of both the 2013 plan and the emerging partial update, and despite the issue having been raised by the HPDG during the course of this application, the appellant has not carried out any monitoring to establish the flow in the streams. Dr. Clothier explained that such monitoring was eminently achievable. However, in an attempt perhaps to cast doubt on the specific role played by the river terrace deposits, Dr. Dewhurst was keen to emphasise the role played by the solid strata in sustaining flows into the streams. There are two fundamental problems with this. The first is that Dr. Dewhurst accepted that she had not carried out any monitoring which would enable her to say what proportion of groundwater flow into the streams comes through the solid strata. She simply has no way of knowing. She acknowledged that the relationship is complex and that all she can offer is hypothesis. The second problem is that in order for the solid strata to recharge and store water, at least some of that water must pass through the river terrace deposits. If the river terrace deposits is removed and replaced by impermeable infill, that ability to recharge will be lost. The extent to which the solid strata is able to draw on other groundwater sources is entirely unknown. Much the same can be said of Dr. Dewhurst's attempt to offer a figure for the average recharge into the springs. Dr. Clothier said that this calculation doesn't give any detail of how the system works. He said, it's guesswork. If you haven't monitored the spring flows, then you have no idea if it is right. Ultimately, Dr. Dewhurst conceded that this was nothing more than a rough water balance calculation. We are therefore left in a position where it is accepted that the river terrace deposits contributes to a sustained flow into the streams, a shallow hydrograph, and where the extent of this contribution has not been empirically measured and cannot be known. This is an unpromising foundation from which to assess the effects of the proposed development, and indeed the fundamental weaknesses in this approach were laid bare by the evidence before the inquiry. The main potential effect, which applies during the operation of the site, but even more acutely following its restoration, is that river terrace deposits will be removed and replaced by inert infill. The permeability of this infill is up to 100,000 times less permeable than the river terrace deposits. It is, to all intents and purposes, impermeable. Indeed, even the surface water management scheme for the restored site is specifically designed to divert all rainwater falling on the site over the surface of the site to the boundary as quickly as possible. It is based on an assumption of zero infiltration into the ground. At the boundary, the water will be directed towards infiltration features, which will then drain into remaining undisturbed river terrace deposits and through them into the streams. And this is illustrated by Dr. Clothier's second CSM at figure 9 as proof. As a consequence, for rain falling on the centre of the site, instead of taking up to a year to travel through the river terrace deposits into the streams, it will be directed straight across the site and reach the streams within a matter of 1 to 2 days. Dr. Clothier was absolutely clear that this could significantly affect the hydrograph, making it much steeper and impeding the ability of the site to sustain flows into the streams over time. In the end, Dr. Dewhurst was forced to admit this. She conceded, "We have no way of knowing how different the hydrograph looks post-restoration, and we don't know how much it will be affected specifically." This was a stunning admission. It seemed perhaps that the penny had finally dropped. After persistently maintaining that the proposed development would have no hydrological effects because it would not affect the quality or quantity of water discharged into the streams, and that the streams would still be fed through the river terrace deposits, Dr. Dewhurst seemed finally to appreciate the point that the HPDG has been making all along, that is that the hydrograph could be significantly affected. Unsurprisingly, in re-examination, the appellant went into damage control mode. Dr. Dewhurst sought to row back on her concessions, suggesting that she did not believe that the changes to the site would have a material effect on the hydrograph. But this was a meaningless qualification, clearly made more in hope than anything else. Dr. Dewhurst's belief is not based on any empirical data, because there is none, and because she has already conceded that there was no way of knowing how different the hydrograph looks post-restoration. Also, given this, there is simply no way of knowing what would or would not be material in this context. Dr. Clothier has also suggested that there may be other effects on the groundwater regime arising from the operation and restoration of the site. For example, during operation, 5% of the groundwater will be used to wash the gravel and retained in the product. This will give rise to a reduction in groundwater reaching the streams. In addition, Dr. Clothier explained that the restoration of the site could affect groundwater flow routes, changing the distribution of water to the streams. These suggestions were not conceded by Dr. Dewhurst, but the HPDG stands by them. At the very least, what can be said following the evidence on hydrology is that the proposed development will have an effect on the hydrograph, it will make it steeper, and there is no way of knowing how significant that effect could be. But it could be very significant if the site drains in a matter of 1 to 2 days, as opposed to months. And then the second part is the implications of the hydrological changes for European sites. Dr. Dewhurst's concession was an unpromising start for Mr. De La Haye, who gave evidence on ecology for the appellant. Up to that point, his evidence about the ecological effects of the proposed development was premised on his understanding, based on Dr. Dewhurst's written evidence, that there is no possibility of a significant hydrological change arising from the proposed development. The admission of such a possibility rather pulled the rug from underneath him. Indeed, Mr. De La Haye admitted that the appellant had not carried out any surveys of the locations where the streams flow into the European sites to establish what habitats and species might be present there, or the extent to which they might rely on the sustained freshwater flows from the streams. He said that this was because he understood that there would be no changes to the quality and quantity of such freshwater flows. Of course, this misses the point, which is not about overall quality or quantity, but about the hydrograph and the significance of the sustained flows of water from the streams. In any event, there was an agreement between Mr. De La Haye and Mr. Andrews as to the European sites in issue, albeit Mr. De La Haye had to admit that he had made an error in overstating the distances from the site to these European sites. Mr. De La Haye and Mr. Andrews also agreed that the site-level objectives for the European site provided a framework for assessing the potential effects of the proposed development on their integrity. The evidence in relation to these is summarised as follows. First, water quality, nutrients for habitat sites. This includes an objective to restore water quality. This is a recognition that the site is currently in an unfavourable condition. Mr. de la Haye accepted that where the conservation status of a site is unfavourable, the possibility of authorising activities which subsequently affect the ecological situation of the site's concerns seems necessarily limited. Mr. Andrews expressed concern that the steepening of the hydrograph would lead to a loss of freshwater input into, for example, the River Hamble in dry and warmer conditions. Those freshwater inputs may have a localised but sustained diluting effect on nitrate concentrations where the streams meet the watercourses. This beneficial effect could be lost as a result of the proposed development. Mr. de la Haye was keen to pour scorn on this suggestion, stressing that he was unaware of any developer suggesting dilution as a means of addressing nutrient concentrations. However, again, this misses the point. Mr. Andrews accepted that whilst this would be an impractical means of mitigation, nobody was suggesting this. Rather, what is happening is the removal of a beneficial effect. In the end, Mr. de la Haye conceded that the existing freshwater input from the streams into the Hamble would have some kind of localised diluting effect, and that no survey had been done to establish its extent. Mr. de la Haye also separately accepted that a localised effect was capable of being a significant effect. The habitat structure, freshwater sources for habitat sites. This includes a site-level objective to maintain the natural freshwater flow and volume into the estuary. Mr. de la Haye accepted that the existing flow from the site into the streams is part of the natural flow. Thus, it must follow that if the proposed development affects the hydrograph, it will affect the natural freshwater flow into the estuary, and thus it will compromise this objective. All that Mr. de la Haye could do in response was suggest that there would be no change. But this position is clearly unsustainable in light of the evidence I've already described. Mr. Andrews explained that whilst the overall quantity, i.e. the volume of freshwater, may not change, his concern lay in the potential loss of the steady, low-level flow of freshwater into the streams. This contributes to a constant trickle into the mudflats and intertidal areas, which can be very important for a range of habitats and species. Supporting the processes, water quality for habitat sites. This includes a site-level objective to ensure that the water quality and quantity is restored to a standard that provides the necessary conditions to support the feature. As Mr. Andrews explained again, this is a recognition of the need to restore, and in this context, taking away something that has a beneficial effect should be avoided. Maintain the physiochemical properties of the water. The site-level objective could also be compromised by a change in the hydrograph for the reasons I've already given. Hydrology and flow within the intertidal area for habitat sites. This includes a site-level objective to maintain the availability of fresh water on mudflats within feeding and resting areas. Some of the streams clearly do flow over mudflats within feeding and resting areas. Indeed, there's photographic evidence of this in Mr. Andrews' proof, which shows one of the streams flowing into the designated estuary at Badnham Creek. This photograph is reproduced below. Mr. de la Haye accepted that in theory the proposed development is capable of compromising this objective, which it obviously is. However, he said that because the qualifying features are highly mobile, a shortage in one area is unlikely to have a significant effect. The problem with this is that, as Mr. de la Haye conceded, he had not surveyed the site or other available sites, and he had not looked at the data. There is no objective scientific data upon which user can rule out any adverse effect on site integrity, certainly beyond reasonable scientific doubt. Therefore, it is abundantly clear from the evidence that there is at least reasonable scientific doubt about the adverse of any adverse effects on integrity of European sites arising from the proposed development. Between them, Mr. Andrews and Dr. Clothier have produced credible evidence of risk, and there is absolutely no objective scientific evidence which can be used to discount it. Given that appropriate assessment must be based on the best scientific evidence in the field and not contain lacunae, this is, we say, fatal to the appellant's case. Before leaving this matter, though, it's necessary to address three other issues. The first is cumulative or in combination effects. Even if it is established that the hydrological changes will not have adverse effects in their own right, they may have such an effect in combination with other plans and projects. This has not been assessed. The second is that hydrological effects were in fact screened out from appropriate assessment entirely. The Habitats Regulations Assessment, the HRA, concluded that there would be no likely significant effect, and that this has been confirmed in recent correspondence with the Environment Agency. This is a reference to the Environment Agency's consultation response of the 17th of April 2024. There are a number of problems with this response, as both Dr. Clothier and Mr. Andrews have pointed out. The Environment Agency accepted that the appellant's hydrological assessment could have gone into more detail. This is unpromising for an assessment which is ultimately being used to discount even the possibility of adverse ecological effects. The EA's response was based on its acceptance that the proposed drainage system would mimic the current groundwater flow discharge to the springs. This completely ignores the possible changes to the hydrograph, which Dr. Dewhurst conceded could occur. And the Environment Agency found that whilst it is believed that there will be no detrimental impact on the European sites, it deferred to Natural England on this issue. Thus, the Environment Agency was rightly acknowledging the limits of its expertise in this area. It was plainly wrong of the HRA to screen out hydrological effects on this basis. Mr. Andrews also maintains that it was also wrong because it involved consideration of mitigation measures, which was impermissible. This was an issue which was the subject of extensive debate at the inquiry, and however, whilst the HPDG would strongly urge you, sir, to accept Mr. Andrews' position, it makes little difference overall because 1, the appellant has conducted a without prejudice appropriate assessment, and 2, as explained above, whether an effect is assessed at the screening stage or appropriate assessment stage, it remains the case that an absence of adverse effects must be established beyond reasonable scientific doubt on the basis of the best scientific evidence. This is simply not possible in this case. The third issue is the position of Natural England. The appellant sets great store by Natural England's lack of objection to the proposed development, including in relation to hydrology. The problem with this is that not only did Natural England not have the benefit of the evidence which you have heard, sir, including Dr. Dewhurst's concession about the possibility of unknown effects to the hydrograph, Natural England's lack of objection was based on an incorrect factual premise. The sequence of events was as follows. On the 3rd of March 2022, Natural England raised a concern about the potential for the Linksgrove and Hackett's Marshes SSSI to be impacted by changes to the groundwater flows from the site. The SSSI forms an integral part of the Solent and Southampton Water SPA and Ramsar and the Solent Maritime SAC. On the 24th of May 2022, Stantec responded to Natural England on behalf of the appellant and stated, "The SSSI is also to the north of Badnham Creek, which is where we would expect groundwater emanating from the northeastern corner of the site to discharge. Therefore, we do not consider that the site development will have any significant impact on the SSSI." Natural England then responded on the 21st of March 2023. It referred to the Stantec letter and stated, "This states that the relatively small flow of groundwater towards the northeast would enter the Badnham Creek and flow into the Hamble. This would prevent any impacts occurring at the Linksgrove and Hackett's Marshes SSSI, which lies beyond the creek." As Mr. Delahaye eventually conceded, it is simply not the case that the SSSI lies beyond Badnham Creek. In fact, the creek runs right through the SSSI, and this is clear from both Figure 4 of Mr. Andrews' proof and Figure 1 of Mr. Delahaye's rebuttal. Given this, all we really know about Natural England's position is that at the point at which it believed Badnham Creek to be in the SSSI, Natural England was not prepared to rule out the possibility of adverse effects from groundwater flows. It is this view that should be given significant weight. Everything that Natural England said about this issue subsequently was based on an incorrect factual premise, and this amounts to a cogent reason for departing from those views, as in any event does the evidence that this inquiry has heard. The points made in Mr. Delahaye's rebuttal about the location of the creek being not being relevant go nowhere. The location clearly mattered to Natural England. Moreover, Mr. Delahaye's rebuttal does not accept or appreciate the changes to the hydrograph or take into account his concession above that the localised dilution of nutrients is possible. I turn now to recreation. The appellant accepts that the site, although private land, is currently used by the public for the purposes of recreation. The appellant also accepts that notwithstanding the landowner's theoretical ability to control access, the proposed development could displace this recreational use into nearby European sites, causing harm to the integrity of those sites. Thus, recreational displacement was screened in as a likely significant effect of the proposed development. It is striking then that despite this, the appellant has not carried out any survey in order to establish the nature and extent of this recreational use or how it might be affected by the proposed development. Rather, the appellant and the HRA have proceeded on the express assumption that recreational use will be displaced to routes immediately available to the area and not the European sites. Assumption has no place in appropriate assessment. It's therefore been left to the HPDG to carry out these surveys. The HPDG's evidence notes that the site is some 60 hectares in area and has been used by the public for well over 20 years for dog walking and other recreation. It's described by residents as an open, rugged, natural space where people and dogs can roam free. Of some 690 respondents to a recent survey, 95% said that they used the airfield, 72% more than twice a week, and 65% for dog walking. Respondents noted the open wild space, which was particularly conducive to walking dogs off their leads. The proposed development will fundamentally change this. The ability to roam freely across the site will be gone and replaced by a 3-metre wide permissive path on a strip of land that varies in width from 70 metres at one short point to a few metres in a large section of the northwest and west, but is bordered by a fence on one side and a 3 to 5 metre high bund on the other, with a much reduced community access meadow to be provided only after restoration. Respondents to the HPDG survey said that they were overwhelmingly unlikely to use the site following the proposed development. Instead, they're likely to use other locations in or much closer to European sites. This survey has been criticised by the appellant as being biased. Mr. Andrews accepted that an element of bias could be present in the survey. However, any suggestion that the survey was carried out in bad faith is entirely rejected. Moreover, the survey is the only and the best empirical evidence that this inquiry has about the potential effect of the proposed development on recreational displacement. The appellant has also been keen to suggest that the possible impacts from recreational use of the site of the European sites, which could be caused by the proposed development, have already been factored into existing mitigation strategy, which requires contributions towards mitigation measures from residential development close to the sites. However, this is incorrect. As Mr. Andrews explained, this strategy was based on surveys of local residents who will presumably have been asked where they went for their recreation. Respondents who used the site can be assumed to have responded accordingly. Similarly, any surveys of the European sites themselves will have been affected by the existing mitigation provided by the site. In other words, the European sites would have been in a better condition than they would have been without the site. Indeed, Mr. De La Haye accepted this. His response was simply to suggest that it's likely that the number of people using the site would have had no impact. This is yet another assumption, and it is clearly not good enough. Overall, it certainly cannot be said with any confidence that the existing mitigation strategy provides for the effect of recreational displacement from the site. Rather, the recreational use of the site is likely to have been baked into the strategy, such that the impacts of the site's loss have not been accounted for. Overall, then, it's quite clear that reasonable scientific doubt exists about the absence of adverse effects on the integrity of the European sites arising from the displacement of the existing recreational use of the site. Finally, and in addition, as Mr. Andrews has explained, there has been no adequate assessment of the in-combination effects of recreational disturbance. So, in conclusion, for either or both of the reasons I've already given, Regulation 63 of the Habitats Regulations requires that planning permission for the proposed development be refused. And for completeness, the proposed development is also contrary to Policy 3 and 20 of the Minerals and Waste Plan and Policy DM 11 of the Eastleigh Local Plan. Turn now to look at highways impacts. 3 issues are raised by the HPDG. First, the effect on the highway network. Second, the effect on highway safety. And third, the adequacy and feasibility of proposed mitigation. The effect on the highway network. Traffic is obviously a serious problem on Hamble Lane, which provides the only access to the site from the main highway network. This came across clearly from the local residents, teachers, businesses, cyclists, and others who gave evidence at this inquiry. Hamble Lane is highly congested and it is very sensitive, with a single incident capable of causing complete gridlock. This is formally recognised by the County Highway Authority and the Minerals and Waste Planning Authority. Mr. Whittingham has highlighted that as long ago as 2015, the Eastleigh Transport Study identified that Hamble Lane suffers from serious congestion. It identified the potential for a number of strategic improvements, but none of these have happened. Things have not improved. The Eastleigh Local Plan 2022 again identifies Hamble Lane as suffering from serious congestion. Indeed, so bad is the situation that the County Highways Authority has adopted a policy of not allocating or permitting any further development along Hamble Lane until a preferred scheme of works to the northern section of Hamble Lane is implemented. Despite this, the County Highway Authority has somehow found its way to approving the proposed development. This is bizarre and wholly unjustified. The County Highways Authority suggested that its policy of opposing further development on Hamble Lane does not apply in this case because the proposed development has already been allocated in the plan. However, the allocation was now some 12 years ago, since which time there has been other development in the area, but no highways improvements. It nevertheless remains that even without the allocation, there is serious congestion on Hamble Lane, which the County Highways Authority deems sufficient to block any other form of development. And in any event, the allocation was based on a prediction that the development of the site would generate 30 to 60 HGV movements per day, that should say, not the up to 126 movements that are currently proposed, i.e. over 100% more. The County Highway Authority relies on the modelling which has been carried out by the appellant. However, modelling can only go so far to predict the effect of development on a highly congested and sensitive network. In any event, the appellant's modelling is flawed. It's based on 2022 traffic counts. It makes no allowance for increases in traffic after that date or throughout the duration of the development. The appellant seeks to justify this on the basis of a 2024 traffic count, which it says shows that congestion is in fact falling. The appellant's confidence is misplaced. The appellant has compared the 2024 data against traffic count data from just one day in October 2022. Mr. Whittingham stated that he did not think that this was a solid evidence base on which to model. Mr. Hillman also pointed out that the appellant had used just 4 hours of counts, 2 hour AM and PM peaks, instead of analysing traffic counts across the day. Mr. Hillman explained that Hamble Lane can experience different peaks. Moreover, the appellant's traffic survey in April 2022 took place between Easter and the May bank holiday, which Mr. Hillman suggested was unlikely to be an accurate representation of typical traffic. The appellant's 2024 count was undertaken on the 11th to 17th of October. This was during a time of major traffic disruption in the local area. The appellant has accepted that between 9 PM on the 15th of October and 6 AM on the 19th of October, the M27 Junction 7 eastbound off-slip was fully closed. That is 3 out of the 5 working days surveyed. As Mr. Hillman explained, these works and others gave rise to a 4-day period which the local newspaper described as Carmageddon. He quoted the local councillor who said, over the past 3 days, there's been a coincidence of different events that have led to unusual levels of congestion. However, Mr. Hillman explained that the County Highways Authority and National Highways, he explained that the County Highways Authorities and the National Highways had warned people in the days preceding that week to anticipate congestion. No wonder, as Mr. Hillman subsequently explained, traffic counts were shown to be decreasing in 2022 and 2024, particularly at peak times. In addition, without speed data, there is no way to determine if falling traffic counts reflect falling traffic demand, the appellant's view, or deteriorating traffic conditions and increasing congestion, the HPDG's view, as supported by the many speeches and submissions that you've heard by interested parties and the thousands of earlier written objections. Unfortunately, no speed data has been presented by the appellant to distinguish between these two scenarios. Therefore, it's left to you, sir, to determine whether the counts were low because the traffic was moving more slowly. A wholly unsatisfactory position, simply because we say the appellant has not done the work it should have done. For his part, Mr. Howard, for the appellant, has sought to rely on a comparison between what he says are the affected days and what he says are the unaffected days. He suggests that this shows no real difference. Mr. Howard was forced to acknowledge an error in this analysis since he had mistakenly included Friday the 18th of October when no monitoring took place. Even more significantly, though, as both Mr. Whittingham and Mr. Hillman explained, Mr. Howard's analysis wrongly assumes that the 14th and 15th of October were totally unaffected by traffic disruption, when this is not the case. See, for example, the local news reporting I've referred to. The HPDG carried out its own count in January 2025. Mr. Howard accepted that this shows an increase in daily flows compared with October 2024 of 11% on average. He was dismissive of this, though, and suggested that the focus should be on peak flows. However, as Mr. Whittingham explained, 24-hour flows are helpful in understanding peak flows. They could mean increased congestion, which has the effect of flattening peak counts because traffic takes longer to pass. In any event, whilst the 2025 data showed some decline in peak flow compared with the 2022, this was not the case in relation to southbound flows in the northern end of Hamble Lane between 8 and 9, which are shown as having increased by 20%. Mr. Whittingham was criticised for only including data from the 2025 traffic count relating to the northern end of Hamble Lane, not the southern end. However, he clearly explained that his motivation was to focus on the effects that the proposed development would have on the highway network at the north end, where congestion is most acute. This location enabled a comparison with the DFT annual numbers and demonstrated that overall traffic has continued to increase at that location. The picture of growing congestion on Hamble Lane is corroborated by the DFT traffic counts, which were provided by Mr. Whittingham. The orange dots are informed estimates taken from some 7,500 data points and extrapolated to demonstrate a steady and steep increase in the flow since COVID. The flow measured by the HPDG in 2025 is broadly in line with this trend. This seriously undermines the robustness of the appellant's modelling, and it follows that the appellant has not modelled all reasonable future scenarios, contrary to paragraph 116 of the NPPF, and that its analysis should be rejected accordingly. In fact, though, even if the appellant's modelling is taken at face value, it indicates that the proposed development will have a severe impact. It is, of course, accepted that the appellant's modelling is based on an assumption that there will be 144 HG movements per day during peak operations, as opposed to the 126 now proposed, but it is the only data that this inquiry has. Mr. Whittingham was clear that the difference was not material. He also highlighted the fact that the appellant has not done any junction assessments to establish how delays at different junctions interact with one another. Mr. Whittingham has identified the GE Aviation appeal, which provides a ready template for assessing impacts of development on Hamble Lane. Indeed, the GE Aviation site is just over the road. In that appeal decision from 2021, the inspector recognised that Hamble Lane is subject to serious congestion at peak times, with key junctions already operating over theoretical capacity. He noted that increased queue times at the worst affected junctions were such as to give rise to severe impacts for the purposes of what is now paragraph 116 of the NPPF. Mr. Howard did not dispute the extent of the increases identified by Mr. Whittingham, but he sought to distinguish the importance of the GE Aviation scheme appeal for several reasons. This is a false distinction. First, Mr. Howard said that the proposed development is a minerals development and that you have to take minerals where you find them. However, if this point is relevant at all, it is for the planning balance. It is not relevant to whether the impacts of development are severe. Second, Mr. Howard suggested that the County Highways approach to mitigation has changed since the GE Aviation decision. However, again, this is not relevant to whether the impacts are severe. All the factors that justify the inspector's approach in the GE Aviation appeal still pertain. In particular, Hamble Lane remains highly congested. The inspector highlighted notable negative impacts at specific locations, which he seems to have regarded as anything over 10 seconds. He particularly identified an increase in evening peak queue length at the Tesco roundabout of 1 minute to 3.5 minutes, a 40% increase, and an increase in morning peak queue length at the A3025 junction, 30 seconds to 3.5 minutes, a 17% increase. Mr. Whittingham has identified comparable increases in this case, an increase of 40 seconds to 120 seconds, 50%, in the morning peak at Hamble Lane, Satchel Lane, an increase of 23 seconds to 140 seconds, 20% at the A3025, and an increase at Lionheart Way of 40 seconds to 119 seconds, 50%. Mr. Howard did not dispute any of this data. It provides a clear basis upon which to conclude, consistently with the inspector in GE Aviation, that there will be a severe impact on the highway network, contrary to paragraph 116 of the NPPF. The effect on highway safety. The map included at the beginning of these submissions shows that in addition to being served by a seriously congested road, the site is close to a number of amenities which are likely to create pedestrian and cycle activity within the vicinity. All of these road users are vulnerable to HGV traffic, which will increase by up to 34% overall as a result of the proposed development. But this marks the most concerning impacts, including an increase of 113% in the vicinity of the site access during the AM peak. This is, as this inquiry has heard, a major concern to local residents and particularly the schools, whose pupils account for much of the pedestrian and bicycle traffic around the site at peak times and who have expressed concern about fear and intimidation. One specific concern which has been raised by Mr. Whittingham is the safety of the site access, which will bisect the Danny King cycleway, a shared use path to the east of Hamble Lane. Analysis of the appellant's own projections of arrivals and departures of HGVs at the site access demonstrates that during phase 2 of the development, there will be 11 to 12 arrivals and departures between 7 and 8. This means that one HGV may cross over the cycleway every 2.5 minutes. Between 8 and 9, there will also be 7 to 8 arrivals, more than one every 10 minutes. This was all accepted by Mr. Howard. There will be no departures during this time because the appellant proposes to restrict them between 8 and 8:45. However, these HGVs will have to leave at some point, and realistically, these are likely to be concentrated around the minutes leading up to 8 o'clock in the morning in order to avoid being locked into the site. Mr. Howard accepted that it is possible, therefore, that HGVs may cross the cycleway even more frequently than once every 2.5 minutes just before 8 o'clock. Whilst all this is going on, children will be streaming across the site access. There will be one child crossing every 20 seconds between 8 and 8:30, and about one every minute between 7:45 and 8 o'clock, when HGVs are both arriving and departing. Again, Mr. Howard accepted these figures. This demonstrates how inherently inappropriate the site access is. Mr. Howard accepted in principle that the presence of a number of children is a factor that has to be borne in mind when assessing the safety of highway access. He also accepted that a highway scheme is only as safe as its least safe element. In addition to the general concern outlined above, a number of specific safety concerns were identified in the road safety audit, which Mr. Whittingham maintains presents an unacceptable risk. A 16.5 metre HGV accessing the site will have absolutely no margin for error. The appellant's only answer to this concern, which was flagged by the RSA, is to say that the majority of HGV movements will be undertaken by shorter vehicles. However, this does not actually address the safety concern. It does not rule out these vehicles arriving when school children are passing by. The stream of children passing the site at peak times, observed as being spaced about 5 to 10 metres apart, may mean that the HGV operators are required to wait for significant periods of time on Hamble Lane to give way to them. This will block Hamble Lane and could give rise to dangerous overtaking or undertaking manoeuvres as drivers lose patience. The appellant's only answer is to block departures at certain times, and so suggests that arrivals during this time will be infrequent occurrences. But that is not an answer. There will still be arrivals, and these will happen many times a day, including at peak pedestrian times, every day for over a decade. At the end of the day, neither an allocation in the Minerals and Waste Plan nor a road safety audit means that an acceptably safe access can be provided here. There are widespread and well-founded safety concerns, which should be given particularly serious weight since they pertain to children. The adequacy and feasibility of proposed mitigation. It should be stressed that the HPDG's position is that the proposed mitigation will not be sufficient to address the unacceptable risks to highway safety or the severe impacts on the highway network identified above. Indeed, there's been no specific modelling or assessment of the effects of this mitigation. It is the agreed position of the County Highways Authority and the Minerals and Waste Planning Authority that mitigation will be required to address the highways impacts of the proposed development. That mitigation is described in detail in the Statement of Common Ground. Mr. Whittingham has explained that much of this mitigation cannot be delivered in the manner envisaged due to physical constraints. Some of this is accepted by Mr. Howard. Mr. Howard maintains that there will still be betterment, but this cannot be reconciled with the County Highway Authority's position. This suggests that all of the mitigation described in the Statement of Common Ground needs to be delivered to address the impacts of the development. Otherwise, that mitigation could not be the subject of a planning obligation. If the mitigation cannot be delivered as envisaged, then there will be residual harm. There is also real concern about how the £500,000 contribution has been arrived at. An email dating from March 2023 clearly states that this figure was reached on the basis that 200 metres of shared surfaces would be delivered. This 200-metre figure was repeated in the committee report and Ms Kirby-Hawkes' proof. It was then repeated again in the information provided to Ms Kirby-Hawkes by the County Highways Authority, which ultimately led the Minerals and Waste Planning Authority to withdraw its objection to this appeal. However, it is now accepted that the mitigation will comprise at least 741 metres of shared surfaces with all necessary accompanying works. But despite this, the £500,000 figure has remained unchanged. It is now suggested that it was a typographical error. This is not a credible explanation in light of the March 2023 email and the repetition of this figure on at least 3 further occasions. It does not fit with the only actual data on costings that the County Highway Authority has provided, which all demonstrates that it will cost substantially more than £500,000 to deliver 741 metres. When pressed to identify which of these examples led her to decide that this figure was sufficient, Ms Kirby-Hortz could not say. She could only report to the County Highways Assessed statement that the costs for these types of schemes does vary. This is almost certainly true, but it doesn't help in circumstances where none of the costed examples are anywhere close to the suggested amount. It also raises a serious question about how carefully this application has been scrutinised by the Minerals and Waste Planning Authority. Mr Whittingham has subsequently submitted a note to the inquiry which shows that a £500,000 contribution is indeed wholly inadequate. Conclusion. For the reasons I've given, the proposed development is contrary to paragraph 116 of the NPPF. Further, or alternatively, it is also contrary to policy 12 and policy 20 with appendix A of the HWMP and policy S11(1) of the Eastleigh local plan. Turning to the planning balance, as I've explained, the proposed development must be refused pursuant to regulation 63 of the Habitats Regulations. Further, or alternatively, it should be refused because it is contrary to paragraph 116 of the NPPF and the highways policies of the development plan I've cited. Amazingly, despite being a qualified planner, Ms Pearman declined to assist the inquiry by offering a view on this alternative scenario. Ms Pearman did accept that in a scenario where harm is registered at less than the thresholds in paragraph 116, but is still contrary to the development plan, or if other harm is identified, a planning balance will need to be undertaken. This will require consideration of the benefits of the proposed development. The principal benefit relied upon is the supply of aggregates, but before addressing that, it's necessary to address some of the other alleged benefits. Whilst there may be some employment created by the proposed development, Ms Else for the HPDG was clear that this will not be at a level that will substantially benefit the local community. Ms Pearman accepted that any benefit from business rates would be a tiny little thing. In fact, in reality, she went further, since she accepted that she did not know whether the payment of business rates would make the appellant a net contributor or net beneficiary of council services. This is therefore not a benefit that can be given any weight. Ms Pearman also accepted that any aggregate levy would be payable wherever a site is. As Ms Else explained, if this site does not come forward, but aggregate is still needed, the levy will still be extracted from another site. This is therefore not a particular benefit of this development. The provision of a permissive footpath is not viewed by residents to be an improvement on the existing situation. Ms Else was clear that to the extent it is a benefit at all, it is not sufficient to justify the proposed development. Turning to the supply of minerals. The approach to this is clearly set out in the NPPF. Paragraph 224 provides that great weight is to be given to the benefits of minerals extraction. Ms Pearman accepted that the level of these benefits will depend on the level of need and supply. Paragraph 226 of the NPPF explains how minerals planning authorities are to maintain and judge need and supply. They are to maintain a land bank of at least 7 years for sand and gravel. In order to judge the extent of that land bank, they are required to prepare an annual local aggregate assessment, or LAA, to forecast future demand based on a rolling average of 10 years sales data and other information. This clearly demonstrates the importance of having up-to-date data, something Ms Pearman accepted. The most up-to-date data that this inquiry has is the 2025 LAA. This makes it absolutely clear that on the basis of the permitted reserves alone, so not including the site, Hampshire has a land bank of 12.95 years worth of sharp sand and gravel and 12.59 years of sand and gravel overall. Even based on the 2023 APR rate, which is marginally above the 10-year rolling average, there is a land bank of 12.16 years, or 11.1 when adjusted for 2025. This is on any measure an abundant supply. Despite this, and despite her acceptance of the importance of considering the up-to-date data, Ms Pearman fixated on the 2013 local requirement established in Policy 17 of the plan. That's 1.56 million tonnes per year. However, even on this basis, there's a land bank of 7.39 years of sharp sand and gravel, according to the 2025 LAA. What is more, if Ms Pearman is in fact correct to say by 2025 this will have fallen just below 7 years, it's wholly artificial, and it is a wholly artificial and pointless measure, given that the local requirement is so much higher than the 2023 APR. And this is starkly demonstrated by the emerging partial update, which sets a significantly reduced and much more realistic local requirement of 0.9 million tonnes per year. To bolster her case, Ms. Pearman was keen to focused on the potential for demand for aggregates to increase following from the government's target to build 1.5 million new homes this Parliament. However, this prospect was specifically considered in the 2025 LAA, which concluded that in the short-term future, 5 years, it is anticipated that there will be a continuation of the level of demand for aggregates in Hampshire. It stated that whilst this target could signal a future increase in demand, it is not clear when the demand would be established, and any demand may be tempered by delivery constraints. There are obvious delivery constraints in the local area, not least due to the highways issues on Hamble Lane. In any event, the LAA is also clear that there is capacity to increase output if necessary, with sites recorded as currently operating with sites recorded as currently operating at 60% capacity. Need can also be met by the increased use of recycled aggregates and, in some but not all circumstances, by marine one aggregates. Ms. Pearman was keen to stress the site's allocation in both the existing and emerging minerals plans. But as she has accepted, allocation is not a guarantee of permission, and policy 20 of the plan accepts that some delivery may come from windfall sites, as has happened in the past. The partial update recognises that historically these opportunities have played an important role in meeting Hampshire's demand for local land want aggregate and can help address any shortfall in supply. Ultimately, the need for the proposed development is nowhere near enough to justify its harmful effects. Indeed, it is well worth noting that this was the position taken by the Minerals and Waste Planning Authority itself when it decided to refuse planning permission and maintained that position on highways grounds alone right through to March 2025. The HPDG would also stress that the availability of inert infill material to carry out timely restoration of the site is an important consideration in this decision. Finally, as I've noted, it is a matter of significant concern that there has been a last-minute change to the Section 106 agreement. The appellant now seeks, among other things, a clause that will discharge any obligation to implement and maintain the Ecological Mitigation Management Plan in the event that a new planning permission is granted. It's understood that this clause has been insisted upon by the landowner, Ideal Homes. The intention behind it is obvious. The landowner wants to convert the site for housing and does not want to be burdened by this mitigation. However, this mitigation has been deemed to be necessary for the scheme to be acceptable, and as such it should be guaranteed. Otherwise it can be given no weight, and it's no surprise, as I've already said, that the Minerals and Waste Planning Authority has robustly opposed this amendment. Conclusion. Because it is not possible to rule out the risk of an adverse effect on the integrity of European sites, planning permission must be refused. And if this is not the case, then planning permission nevertheless should be refused for all of the reasons I've given. Democracy, and more so local democracy, is a powerful force and should be respected in the planning system. The residents of Hamble, whom the HPDG represent, desperately and overwhelmingly oppose the proposed development. Their contributions to this inquiry demonstrate that their views are not, as the appellant would suggest, based on ignorance or prejudice. They are based on careful and detailed study of the proposed development and its effects. The proposed development is harmful, it is definitely not wanted, and it is clearly not needed. This appeal should be dismissed and planning permission refused. So those are the closing submissions on behalf of the Rule 6 party.
Thank you very much for those submissions, Mr. Fulbrook. I'm inclined to go straight into closing submissions on behalf of the appellant. I'm just going to check that the advocates are okay in terms of comfort break. I'm okay to proceed, but does anybody need a comfort break that would require us to just take a pause in proceedings for a few minutes? I'm not getting any suggestions that we do, in which case I'm going to go straight into the closing submissions of Mr. Strawn. If you can just bear me 1 minute, Mr. Strawn, because I do need to load yours. Just bear me 1 second. I now have those, Mr. Strawn, on my computer, so please commence your closing submissions when you feel able to do so.
Thank you. So do you want me to look for a break at all?
No, unless you've, no, I'm absolutely fine, unless you feel that there's an appropriate break that you would need. I've not got any signs from any of the other advocates that they are desperate for a break, so
That's fine. Mine are a bit longer, I'm afraid. So if at any stage you need a break, then just shout.
I think I wouldn't normally ask for interjections, but if people do need a break, the maybe best way to do it is to just raise the hand on the Teams bar, and then I'll move from there. Right, when you're ready, Mr. Strong.
Thank you. At the outset, the appellant identified that this is an appeal which should never have been necessary, and the further testing of the evidence has emphatically demonstrated that to be the case. And it is extraordinary that in a plan-led system, where this site is specifically allocated in the currently adopted local plan for the development proposed, the relevant planning authority and every expert statutory consultee has now agreed the development can occur acceptably, that the appellants had to seek consent by appeal under Section 78 of the 1980 Act. And this exemplifies some of the basic problems of the planning system, along with the blatant disregard for the advice in the framework that such development should be approved without delay. And it's ironic that the maximum period of activity for this temporary mineral extraction, I'm thinking of the 4 years for when 126 HGVs would operate, now exceeds the time which is taken for this application to be finally determined. But the problem the appellant has faced is particularly disturbing where the development is for a vital proposal for the extraction of critical sand and gravel to address the area's mineral needs. The development for those minerals from an allocated site has been deliberately chosen for its sustainable location. The site can specifically serve the many forms of development required in the South Hampshire area, be it housing, affordable housing, or basic infrastructure for sustainable growth that are inevitable. That's why we described it as literally providing the essence of the building blocks of a sustainable future. So in these closings, we'll seek to address why there is no proper basis for objection, why the case for allowing the appeal is overwhelming, albeit it's unnecessary to go that far. Determination in accordance with the development plan and national policy itself requires the appeal to be allowed anyway. Dealing first with policy and need, as we said in the opening statement, paragraph 222 of the framework identifies that it is essential that there's a sufficient supply of minerals. And since minerals are a finite natural resource where they can only be worked where they're found, best use needs to be made of them and to secure their long-term conservation. National policy prescribes that when determining planning applications, great weight should be given to the benefits of mineral extraction to the economy. And we say it's unfortunate that the HPDG, that's the Rule 6 party, and its planning evidence failed to do that in its assessment of the planning balance. In this case, the appellant is proposing such extraction in a way which avoids, for example, requiring minerals from within any national park or other designated areas. It ensures there are no unacceptable adverse impacts on the natural, historic environment or human health, ensures any unavoidable noise, dust, particle and emissions are controlled, mitigated or removed at source, and deals appropriately with all the noise, and of course provides for restoration and aftercare at the earliest opportunity to the highest environmental standards, such that the proposal fully complies with the development plan and the framework. We therefore remain clearly of the view that there cannot be a better example of sustainable development of this kind than the proposed scheme in this location. Extraction of sand and gravel from a site specifically allocated for it at a location closest to where the minerals are needed for use in the immediate surrounding area, so avoiding the inherently unsustainable prospect of importation of so much of materials from further afield, will assist to deliver what the framework identifies as essential development for a sustainable future. There is, of course, now complete and comprehensive common ground with the planning authority that there are no valid objections that remain and planning permission should be granted. That's further endorsed by the Highways Statement of Common Ground with the local highways authority and the position, of course, of Natural England in relation to the absence of any likely significant effects or indeed adverse effects on the integrity of any of the national network sites, and the satisfaction of the lead local flood authority and the Environment Agency with what is proposed. But as Ms Kirby-Hawkes recognised, it's wrong to characterise the position as one where planning permission can no longer be resisted. Any proper application of the framework and its reasoning means that the grant of planning permission should be strongly supported and granted without. We recognise and understand that it's inevitable that mineral extraction is typically opposed by local residents in the area out of perception about matters like noise, air quality, or traffic impacts. And it has not helped that a large amount of misinformation or misunderstanding has been circulated to self-perpetuate those concerns, including the deeply unfortunate and entirely unjustified suggestion by the local MP that the county authority has not acted properly. As Ms. Els conceded, it is important that such development is appraised objectively and in recognition of the allocation. And as she accepted the long history of that allocation, in light of that, the proposed extraction from the site could hardly have come as any surprise. And of course, even HBDG is not purporting to object on what is to what's proposed on many of the grounds that continue to be treated as of concern by local residents, such as noise or air. We also recognise that it's human nature that the important intrinsic policy need for extraction to occur in this location, the long-standing allocation for the extraction, and the measures in place to avoid any unacceptable adverse effects on the local community are overlooked, and that has happened here. The appellant has done his utmost to be sympathetic to the concerns, even if they're not objectively well-founded. So, for example, it proposed the additional limits on movements from HGVs during years 3 to 7, taking them down from 144 to 126 movements per day. It's restricted HGVs from leaving the sites from 8 to 8:45 and 2:30 to 3:15 during drop-off and collection times for the two schools, in light of the perceptions from the local community. And that's even though both the number of movements originally proposed and the existing use of Hamble Lane by HGVs without such operational hour restrictions would have been acceptable. But whilst the HPD continue to pursue their objections, the determination of this appeal is governed by the plan-led approach. And in accordance with the statutory provisions, the underlying planning application for this development should be determined in accordance with the development plan unless material considerations indicate otherwise. The principle of the development is already established by that allocation in policy 20 of the plan. Another critical material consideration is the framework as mentioned above, and it provides further emphatic support that great weight is required to be given for what's proposed by way of sustainable development where the impacts are all controlled. Another material consideration is, of course, the emerging plan. It strongly reinforces that support. Within the emerging plan, the appeal site is proposed for allocation once again. Indeed, the appeal site forms part of the authority's reserves up to 2035, after which the authority will be dependent on having to try and find windfalls to address the need for the plan period up to 2040. In those circumstances where the council and the statutory consultees have satisfied themselves as to the acceptability of what's proposed, there isn't just a presumption in favour of granting permission in accordance with the plan, but the prescribed great weight must be given to the proposal under the framework. I'll briefly consider the question of policy and need given HPD's apparent attempts to question it. First, and fundamentally, in the context of a proposal to release needed sharp sand and gravels from an allocation, where there's also an allocation in the emerging plan, there is in fact no requirement to demonstrate need for this proposal at all. Policy 20 supports the grant of planning permission subject to the Appendix A criteria being satisfied. The need for the appeal site is already established through the allocation itself. None of the criteria in the adopted plan for the grant of planning permission, nor in the emerging plan, requires need to be established. The site itself makes up part of the area's established reserves for a steady and adequate supply of the mineral to be present. By contrast, it is windfalls which will be subject to an assessment of need. So the question of need is therefore only relevant for underlining the further support for what's proposed, and of course in the event of any material harms arising, outweighing such harms in any event. Second, there is in fact a real and specific need for the release of the appeal site in any event, based on the analysis provided by Ms. Pearman, which wasn't seriously disputed by Mrs. Els. In particular, As a matter of principle, the plan, as required, set out a local plan rate requirement of 1.56 million tonnes per annum of aggregates, of which 1.28 is for sharp sand and gravel. As agreed at the inquiry, the identified current land bank to meet that requirement is already significantly below the minimum 7-year requirement at a level of approximately 6.3 years. And so I don't know if you've got the ability to just make a note on what was, if I could just add in light of what's just been said. But of course, my learned friend in his closing suggested that the rate is above 7 years, but both Mrs. Else and Miss Pearman agreed that the level was below 7 years, because of course one needs to carry out the calculation now. That's why the 6.3 years was common ground with the witnesses. So I hope I won't repeat this. It seems that I've been at a different inquiry, from many of the submissions made by my learned friend simply don't reflect the evidence you will have a note of, but I'm obviously not going to spend all of the time here going through disputes of that kind. Have your own notes. Back to the script, if I may. That 7-year requirement is, of course, a minimum, not a maximum, and it's the local plan rate which represents current policy. Secondly, there's a specific locational need for use of the appeal site now. It's ideally located to serve South Hampshire's development needs sustainably, to prevent minerals from having to be brought in from further afield. And that's specifically recognised by the council in its own analysis. And as Mrs. Else accepted, no one, including HPDG, has identified a better site as a source of minerals to serve that locational need. Thirdly, whilst there is a greater level of supply, if one to use the LAA rate in the latest LAA, as identified by Ms. Pearman, that is not the local plan, and the LAA doesn't factor in the inevitable increases required for delivery of new housing as yet, nor does the LAA rate address the specific locational need for Hamble Airfield as identified in the preceding point. Fourthly, notwithstanding the lower LAA figure based on sales, this figure now being reflected in the partial update, i.e. the emerging plan, HECC has still identified the essential need for the appeal site in that emerging plan using that lower LAA. As Ms. Pearman has explained, it's one of only 4 allocated sites in the emerging plan, which forms a critical part of the reserves for that emerging plan, which itself only provides for the needs up to 2035, despite the plan period running to 2040. And as I've already noted, after that period, they'll have to look to windfalls. So it's simply absurd to suggest that either the LAA or the emerging plan has diminished the recognised need for Hamble Airfield as a source of sharp sand and gravel for Hampshire's requirements. And of course, that need is again location specific for all the reasons I've identified. Its location has not changed, and there are no other better sites, despite 22 sites having been examined, with only these 4 being proposed for allocation. And fifthly, the need is now all the more acute in light of the identified requirements for new housing in Hampshire under the framework and the standard method for calculation. As was common ground, the LAA does not take account of those hugely increased needs at all, but flags them up as needing to be addressed, as covered by Ms. Pearman in her evidence. The requirement for minerals across Hampshire, including the Eastleigh area and South Hampshire, is only going to rapidly increase if anything like the required housing numbers are to be met. These new housing requirements exist now. The need for a release of the appeal site in anticipation of those needs is therefore overwhelming if one is to have any hope of the steady and adequate supply that the framework requires. It's simply fanciful to try and undermine that need for the appeal site minerals to be extracted. Reality is that it is required, along with very substantial contributions from other sites yet to be found. Mrs. Else also half-heartedly sought to suggest that the need could potentially be met because of extensions of time at other sites being indicative of a lack of demand, or need could be met from marine one aggregates or by uplifts and recycling. And for your note again, that those are referred to again in closing without reference to the cross-examination, because each of those points turned out to be misconceived. As to extension, Mrs. Else accepted in that cross-examination that her Annex KE4 on proper analysis did not support her thesis. The need for extensions was not being driven by a lack of real demand now, but a host of site-specific reasons, such as for Bleak Hill, delays in planning agreement, in agreeing planning agreements, and in respect of Brams Hill, identifying the very problem that the government is seeking to avoid, namely the absence of a steady and adequate supply, which might otherwise inhibit needed and planned development. As to Marine One aggregates, as Ms. Pearman pointed out, this is subject to its own identified separate supply requirement in the plan and the emerging partial update, which rate has never been met, 2 million tonnes per annum. So it's fallacious to try and suggest that it can be used to make up a shortfall in Land One aggregates at all. In addition, as Mrs. Else accepted, Ms. Pearman had identified that it cannot always be a proxy for Land One aggregate because of its chlorine and shell content. For some applications has to be mixed. And in addition, any ramping up of supply for Hampshire of this aggregate will face its own problems and challenges, such as the Wolves facing similar transportation issues of increasing export. They have the limitations on plant and stocking areas, and they're already facing their own competing pressures in terms of regeneration. As to recycling, again, Mrs. Else accepted Ms. Pearman's correct analysis that recycling of aggregates is already factored into the plan and the partial update rates, with ambitious and stringent targets already set, and that the 10-year sales data in the LAA shows will be a challenge to meet. The need for Hamble airfield is already premised on such ambitious targets being achieved for recycling. Accordingly, for all those reasons identified in more detail by Ms. Pearman, we submit that the Council was entirely right to recognise the specific need for the release of Hamble and the minerals it can provide now. It is a quantitative need, it is a qualitative need, and it is a specific locational need for sustainability purposes. There is no better site that anyone can identify to meet those needs sustainably. Finally, the only other point raised by Mrs. Else in this regard was to put forward a contention that the proposed development might in fact take longer to restore than is being proposed within the appeal scheme, on the basis that there will not be sufficient inert fill available. She sought to draw upon your own decision in respect of a proposal at Lee Castle in a Greenbelt location, where the specific potential prospect of delayed restoration in that case could have potentially prolonged the harm to the greenbelt that was being identified. This argument and the comparison proved to be inappropriate and inapplicable here for a number of reasons. First, in contrast to the position considered in the Lee Castle area, there is no evidence at all to support the assertion that there may be a lack of inert material to enable the restoration to take place as planned. To the contrary, there's positive evidence that there is no such problem. The appellant already operates a site in Hampshire, which is subject to restoration and has no problems with any supply. The council itself, as the Minerals Planning Authority, has confirmed it's unaware of any such issues. This is therefore idle speculation and contrary to the evidence. Secondly, and in direct contrast to Lee Castle, the proposed scheme is not one which involves any use of greenbelt land or land subject to any equivalent designation where there is some harmful effect occurring in landscape visual or planning designation terms, which would make any extension, in the very unlikely event it was sought, unacceptable anyway. Third, as Mrs. Else eventually conceded, the only harms that were being asserted in relation to the use of the appeal site were not ones which would in fact be aggravated if such an extension was sought. So, for example, if restoration did not occur as planned, there's no reason to think it will not, because of the absence of inert material, then the associated HGV movements importing the fill would not have occurred. And if they were then to occur over a later restoration period, they would not be increasing any traffic congestion issue beyond that which has already been assessed and considered acceptable. Similarly, no other hydrological or recreational effect would be generated beyond that which is already deemed acceptable. And the only resulting delay would be in the final completion of the restored area, but the permissive path and landscaped area and meadow would all continue to be available. So the completely unevidenced prospect of any delay in restoration is therefore incapable of being a basis for objection to this scheme in any event. And of course, lastly, the appeal site is close to the urban areas, which will be the natural source of such inert material, again in contrast to Lee Castle. So for all the reasons explored in Ms Pym's evidence and in the supporting material, we submit there is no requirement to demonstrate need given the allocation that recognises the need for the site and the supply of minerals. Notwithstanding that, there is clearly a specific need, both in terms of the local plan rate, but also more specifically locationally, and under the newer low rate in the emerging plan, where the appeal site continues to be allocated. Thirdly, the beneficial locational characteristics of the appeal scheme and the absence of any better or more sustainable site means that the merits are overwhelming. Secondly, the need case becomes all the more acute when one recognises the incontrovertible requirements for a huge uplift in the delivery of housing in this area, which will necessarily depend upon minerals that this site can provide. There are no other sustainable sources of supply to substitute for those represented by the appeal scheme. Both the existing allocation and the emerging allocation, coupled with the application of the framework, demonstrate why great weight must be given to what's proposed to make best use of the site, where, as we address elsewhere, all the other impacts of development have been fully assessed and mitigated. So I turn to those other considerations with that in mind, with a focus on those issues raised by HPDG, but before dealing with their points, I deal briefly with the full compendium of planning considerations. These have inevitably not been the subject of a specific focus at the inquiry. That's because they're not in dispute between the main parties. But it is important not to lose sight of them in assessing the compelling merits of the development and in answer to the concerns of third parties. In putting together the underlying planning application, the supporting environmental statement, and the wealth of technical material, the appellant has carried out a comprehensive analysis of all the relevant planning considerations, covering all topics such as noise, dust, air quality, human health, ecology, all of which are matters of concern to the local community. We recognise they are concerns, but we also emphasise the importance of objective empirical assessment in accordance with well-established standards. That's exactly the process that the appellant has followed. In turn, those assessments have been thoroughly scrutinised by the council with its own in-house expertise. Moreover, where the council has considered it necessary, it sought independent expert advice on the appellant's expert materials. A good example of this is in respect of air quality. The appellant's own assessments of the way in which the appeal scheme can be delivered through construction, operation and restoration in a way which ensures no unacceptable impacts on any person in terms of air quality. That includes, of course, the established mechanisms for ensuring no unacceptable effects from dust generation and the use of well-tested techniques for preventing such effects. But the council has not simply deferred to the appellant's own independent experts in that respect, but subsequently instructed its own. They also have confirmed independently the acceptability of those assessments and those results. Accordingly, whilst we note that third parties note that third parties continue to express concerns and did so at the inquiry, reality is those concerns are based on perceptions rather than objective evidence data. In all the supporting material covering the full range of topics, supported by additional information where it's been requested, the appellant has demonstrated that the proposed scheme extraction can indeed take place without giving rise to any unacceptable effects in respect of all these subject areas. This is the very opposite of not showing regard or sensitivity to the residual concerns expressed. We know that people continue to express concerns about noise at the schools or noise at their properties or dust generations affecting boats. But the position is that those matters have been all thoroughly assessed. Compliance with now well-established standards will ensure acceptable levels of amenity, and that's all being demonstrated. So whilst we recognise that residents may still have fears that the scheme will be noisy or dusty, or schools will be adversely affected, the objective evidence demonstrates that these concerns are not justified in reality. The appellant additionally has a wealth of experience of operating such sites in close proximity to residential areas and schools. As Ms. Pearman explained, although fears are always expressed in the application process, the reality of the development itself, with all the safeguards in operation, time and time again result in the fears being unfounded. I therefore incorporate, but don't repeat, that technical appraisal information in response to the third-party concerns where they've been articulated at the inquiry itself. I commend the assessments to you and, of course, to the third parties. Unless you require any further information on those topics, I'll now focus on the main issues, the issue between the main parties that being covered at the inquiry itself. Dealing first with traffic and transportation, HBD's principal source of objection, and that repeated most often by third parties, related to highway issues and the impact of HGV traffic from the use of the site on the road network. The starting point for this consideration should be the highway statement of common ground, as well as the common ground now reached with the Minerals Planning Authority. Following extensive analysis of the proposed development by the appellant's expert transport consultants, the changes to the proposed development, either requested by the council or simply volunteered by the appellant, we submit there can be no doubt that there is no reasonable basis for objection to the scheme whatsoever. Although it's perhaps inevitable that there will remain objection from local residents and HPTG as to the effects on highways, from what's proposed, proper objective analysis reveals those objections are not well founded. Underpinned by a comprehensive evidence base, the appeal site is, of course, allocated in the plan for mineral extraction. Therefore, there can be no objection in principle to such mineral extraction and the principle of inevitable highway access to allow it to take place. Policy 12, of course, though, identifies the need for a safe and suitable access to the highway. Highway improvements may be required to mitigate any significant adverse effects on highway or pedestrian safety or highway capacity, environment and immunity. And Appendix A identifies what's required in terms of development considerations, and I won't read those out. This, of course, puts it beyond doubt that the allocation was made in full knowledge of the locality, the nature of Hamble Lane, and the location of the schools in the vicinity of the site. In accordance with the development considerations, the appellant's undertaken a full analysis of those in relation to highways and demonstrated both the safety and acceptability of the traffic impact on the highway network in considerable detail. And in addition, we refer you to paragraph 116 of the framework, and again, I won't read out. In those circumstances, I turn to the remaining objections by HBDG, which we say the evidence has demonstrated to be misconceived. First of all, traffic data. The first point that was pursued by HBD and Mr. Whittingham was a concern relating to the detail of the data collected and presented for the transport assessment and addendum, and as used in the statement of common ground with the County Council. Mr. Whittingham alleged that this related to what he considered to be first, the reliability of the traffic data to form the baseline traffic conditions. Secondly, what he said were alleged shortcomings in the analysis of pedestrian and cycle data. Thirdly, alleged shortcomings in the road safety analysis in the WCHAR. Each of these concerns proved to be seriously misplaced, and more disturbingly, it was in fact Mr. Whittingham's evidence which was unreliable and indeed seriously misleading on the first of these issues. As explained in detail by Mr. Howard, the appellant's experts have collated a large amount of traffic data for the application, far more than would ever normally be expected for a proposal of this kind, generating comparatively few vehicles on the network. And given the length of time it's taken to determine the application and now the appeal, there is now data available from 2016, 2017, 2022, 2024, and now HBG has introduced its own data from 2025. In its modelling work, the appellant has robustly used the 2022 data as representing the baseline conditions rather than seek to adjust the modelling with the significantly lower data that's come from the 2024 surveys. The data reveals that in the morning and evening peak hours, Hamble Lane is already subject to a range of 1,350 to 2,350 vehicle movement with an AADT of 16 to 34,000, with of course the higher flows towards the northern end of that corridor. Some 375 to 850 HGVs already use Hamble Lane every day. As a basic starting point, and you will have already seen this on site, Hamble Lane is therefore a busy, well-used road which already takes a significant number of HGVs on a daily basis. Indeed, HGVs are regular and daily visitors to the south end of Hamble Lane to access the existing employment areas and the oil terminal that lie within Hamble Rice. So whilst residents are naturally concerned by the consequential congestion, the site's context is one where it would take access onto an existing road with high levels of vehicle movement, including HGVs. The development itself would generate 90 additional HGVs per day into that flow for years 1 to 2, then 126 HGVs in years 3 to 7, before dropping back again to 90 HGVs for years 8 to 13. And it's important to note, for the purposes of modelling, however, the appellant assessed the use of the appeal site for 144 HGVs, not the 126 now proposed. And all the modelling work in terms of congestion and queues has proceeded on that overly robust basis. That's because the original proposal was 144 HGVs, but as a result of responding to community concerns, even though the impacts of that higher level are considered to be acceptable, the appellant volunteered to reduce the number to 126 HGVs at that busiest period. It is unfortunate that efforts like that by the appellant to address community concerns have simply not been recognised. The resulting modelling work therefore proceeds on an extremely robust basis, in the sense that it's assessed the effects of the use of the appeal site for 144 HGVs per day, when the reality is only 126 will use it at that maximum period. That period is only between years 3 to 7 in any. In criticising the approach to data, it's bizarre that HBDG and Mr. Whittingham have sought to criticise Mr. Howard's cross-check of the 2022 data with the subsequent 2024 data obtained from further surveys. It's bizarre because Mr. Howard's not actually used the 2022 data for the modelling. He's continued to use the 2022 data, even though the 2024 data shows a significant drop in traffic using Hamble Lane. Once again, this simply demonstrates the robustness of the approach. But HBDG and Mr. Whittingham nonetheless sought to criticise the validity of the 2024 data, asserting it not being representative of the time it was taken, and then seeking to compare it with their 2025 data. None of these criticisms is coherent for the reasons explained in Mr. Howard's rebuttal, evidence, and orally, for which no sensible answer was provided by Mr. Whittingham. First, HBDG has not explained the coherence of attacking that data, rather than the acceptance of the 22 data, which has been used for modelling. Secondly, the criticism of the 24 data on the basis it was collected at the time when there were roadworks at junction 7 of the M27 are completely misplaced, as explained by Mr. Howard in his proof. In fact, junction 7 is some distance where Hamble Lane connects to junction 8. But as Mr. Howard explained, much of the data was collected in the relevant week before the roadworks occurred. And as he's done in table 3.3 of his evidence, he's compared the differences between days affected and unaffected by roadworks, and the differences are inconsequential for the peak hours in issue. So far from the 24 data being affected by the roadworks in issue, the data demonstrates clearly that the vehicle flow is very similar before the roadworks and then when they take place. Similarly, the 24 data does clearly show a real reduction in vehicles using Hamble Lane in the peak hours in issue. Despite that, the appellant's not sought to remodel using the 24 data to show a more benign picture, but it's continued to use 2022 data, which the council itself was satisfied with, which showed the traffic impacts are acceptable. So even with assumed use of 144 vehicles per day and the 2022 flows, despite the drop by 2024, the acceptability of the scheme and the absence of any severe impact has been demonstrated. Fourthly, HBDG's attempted to suggest that its own 25 survey work was showing a different picture proved to be seriously misleading. for the following reasons. First, HPDG only presented daily flows, where in fact, as has always been the case, the traffic modelling is correctly addressing peak hours, which are those of concern for congestion. Secondly, Mr. Whittingham chose only to present one set of data from an ATC to the northern end of Hamble Lane, omitted to provide the ATC data from a counter further south taken at the same time, which shows the opposite of what he was contending. Mr. Howard had to request the data for peak hour flows from both counters. Thirdly, when the data was eventually provided, it actually demonstrates that in the peak hours for the northernmost counter, the flows are in fact reduced from 2022 in 3 of the 4 respects. It's only the southerly flow between 8 and 9 that shows a modest increase. For the southerly counter, which hadn't been provided at all, the picture is very different and the very opposite of the misleading picture that was presented. In fact, in respect of every single flow, the 25 data collected by HPDG itself is showing a reduction in peak hour traffic from that recorded in 2022, which is the basis of the modelling work. Bearing in mind that the southerly counter is the one closer to the appeal site and the areas of congestion said to be of particular concern, the failure to provide that 25 data was inexcusable. Far from providing any support for the contention that the data used by the appellant is unreliable, the 25 data once again confirms the very robust approach the appellant has adopted, using 22 data with its higher flows rather than subsequent data, including that now from 25, which has lower flows. It's very unfortunate that in a climate of misinformation about the appeal scheme, the full picture was not presented publicly in HPDG's evidence, either for your benefit, or also for the benefit of the public, who should have been able to take comfort that the 25 data for peak hour traffic is confirming the robustness of the appellant's modelling approach. Fifth, attempts were made to rely upon press reporting of the roadworks causing what was referred to as Carmageddon. But as ever, the empirical data and records of flows provide the correct picture rather than anecdotal impression. And sixthly, an attempt was made to suggest that if lower flows were being recorded in 24, this would have been because traffic was slowing down, so fewer vehicles were passing. Well, that's not consistent with the counts themselves. But as Mr. Howard explained, he checked that theory and it proved to be false. To the contrary, at times of lower flows for the 24 and 25 data, the recorded speeds were in fact higher. Seventh, and despite clear guidance from the DFT as to the caution to be exercised in using DFT estimates for their counters, and the absence of any data from that DFT counter on Hamble Lane since 2021, the levels were affected by COVID, Mr. Whittingham has sought to use estimated increases to predict a rise in traffic usage in Hamble Lane in the face of the 24 and 25 data, particularly for the southern counter. As Mr. Whittingham, I should say, as Mr. Howard explains, sorry for that, sir. As Mr. Howard explains, the DFT's own disclaimer demonstrates that the estimates are simply that and will not necessarily reflect local conditions. And local data should be used where available, which of course it is here. And in any event, the DFT counts are far lower than the actual counts used in this case. So even if one were to use Mr. Whittingham's projected increase figure for the DFT counter, as set out in ID2, his own table 2 and his proof being wrong, it adds nothing to the picture based on the actual 2022 data that's been used, which is equivalent in any event. So we have no hesitation in commending to you the robustness of the modelling that's been undertaken and the objective endorsement of that modelling by the local highway authority. It's very regrettable Mr. Whittingham has continued to cast aspersions on the data in question when there's no objective basis for doing so. His presentation of evidence on the 25 data was seriously misleading as set out above. He had no sensible explanation for not having provided that data that was in his possession in relation to peak hour flows and the southern counter flow. Turning to pedestrian and cycle data, he sought to criticise what information is in fact already available in the TA and addendum, and the criticism goes nowhere. As pointed out by Mr. Howard, all of that data in his evidence is simply recycling the data already available and presented in the TA and addendum. It doesn't show anything new or not taken into account already as to the nature of the pedestrian and cycle usage and use by school children. To the contrary, the TA and addendum and the council's assessment of the acceptability of it is all based on the assumption of high levels of school children in the pedestrian and cycling makeup. As to road safety, Mr. Whittingham appeared to be criticising the personal injury accident data collated by Mr. Howard, but without any punchline. The fact, as Mr. Howard points out, he's analysed the PI accident data to a much greater level of detail than Mr. Whittingham. And as Mr. Whittingham conceded, the 10-year PI accident data in fact presents a very clear picture. There's not been a single incident involving HGVs in that 10-year period, despite the daily intensity of the use of Hamble Lane by HGVs, including the road bridge south towards Hamble arrives. Far from pointing to anything inherently dangerous in Hamble Lane for the use of HGVs, it demonstrates the opposite. Likewise, in the relevant period in question, of the 9 personal injury accidents recorded involving pedestrian cyclists, only 2 were with school children, and neither involved vehicles, one being a cyclist and scooter colliding, and the other a cyclist falling off by jumping a curb onto deterrent paving. Again, far from demonstrating any existing safety issue, high level of daily use by school children of Hamble Lane, the evidence points the other way. And there's no basis for criticising the WCHAR. It's a document produced some time ago, but of course requires updating as necessary to reflect changes in policy and data as it emerges. Turning then to site allocation and policy compliance, Mr. Whittingham sought to suggest there was some sort of policy presumption against the development stemming from a decision report from the council dated the 12th of March 2019 to the effect that until what was described as the preferred scheme, road changes anticipated to Hamble Lane, it would be considered inappropriate for further development to be allocated or permitted along Hamble. So we say that was misconceived for a whole host of reasons to which Mr. Whittingham had no answer. I'll just pause there for a moment. So, because my submissions are quite long, I wasn't proposing to read out every word of them unless you wanted me to. In certain sections, we set out a summary of what's in the evidence, and I was just going to refer you to that without reading out, and this would be an example, but I'm in your hands.
It's a difficult one because some people won't have read your submissions. I wouldn't normally do this, but I think I'm going to ask on the basis that people are watching today that you probably need to read out as much as you possibly can, I think, Mr. Strong. I do apologise for that, but it's the nature of the biggest we're in today, I think, in terms of virtual closing submissions. So I think for people who's not got immediate access to them, I think we do need to read them.
That's fine. So I'll press on. If you change your mind, you'll let me know.
I won't change my mind. Thank you.
So for the reasons we are identifying, the decision report is clearly not purporting to interfere with existing allocations, nor could it be. The decision report isn't planning policy, nor could it be. That's provided by the plan. Mr. Whittingham's contention is contradicted by the council's own identification that the allocation of Hamble Airfield excludes it from the ambit of that decision report. So we've given you that reference, and that's just irrational cherry picking, therefore, on his part. And Mr. Whittingham's interpretation of the decision report is obviously inconsistent with the partial update by which Hampshire County Council is proposing allocation of Hamble Airfield again. As pointed out by Mr. Whittingham, the council's no longer pursuing the preferred scheme, but instead seeking modal shift measures consistent with the framework in its current form. So the decision report from 2019 obviously is clearly not up to date. Mr. Whittingham also briefly sought to rely upon the fact that the allocation referred to an indication of use by 30 to 60 HGVs, but he quickly accepted that wasn't a policy requirement. And the effect of using the HGV numbers for what was proposed in this appeal scheme had been the subject of detailed assessment. Dealing with highway safety, Mr. Whittingham sought to criticise the safety arrangements of the appeal scheme, all of which have been thoroughly scrutinised in the planning process. The first point he raised was the existence of various local amenities in the area, but of course the original allocation and now the planning application have had full regard to those existing amenities in the assessment. He made reference to the local cycling and walking infrastructure plan, But of course, the proposed development will deliver a contribution of £500,000 to such improvements along Hamble Lane, which will then be enjoyed by all. Mr. Whittingham asserted such improvements will not have any effect, but there's no basis for that assertion. The improvements clearly would improve the facilities for pedestrians and cyclists. That does not mean it will deliver improvements to the whole of Hamble Lane, but there's no requirement to do so. His principal allegation was directed at the design of the site access. And in circumstances where the appellant's already been through the stage 1 road safety audit process for site access design and received endorsement of the council, this was a very strange and unjustified criticism. It's particularly unfortunate that he chose to mischaracterise that process in the presentation of his evidence, given the problems of misunderstanding by HPG and local residents and the need for objectivity. He sought to suggest that the proposed access was heavily criticised in that process. But as the RSA report itself reveals, and Mr. Howard explained, that is a complete mischaracterisation of that process. As Mr. Howard said and Mr. Whittingham conceded, the RSA was carried out by completely independent auditors and reviewed by the council. The council, as local highway authority, has no axe to grind, and they're acting objectively in assessing road safety and impact on the system. Mr. Whittingham accepted the council were particularly well placed to assess the conditions on Hamble Lane from their experience and developments, and he completely dissociated himself from comments made by the local MP alleging willful negligence by the. Again, it's particularly unfortunate that an elected representative should make such unjustified criticisms of its own local highway authority. There is simply no basis for the allegations, as Mr. Whittingham conceded. The highway officers had satisfied themselves of the safety of the access arrangements as presented in the relevant drawings that are currently before you, as confirmed in the Statement of Common Ground. And during the cross-examination, it became apparent Mr. Whittingham was not properly aware of the content of that Statement of Common Ground, but when directed to its terms, he accepted that they had in fact satisfied themselves, having regard to the RSA outcome, and that there were no residual safety issues in light of that RSA process. What Mr. Whittingham alleged to be heavy criticism was in fact simply the raising of 3 points identified in the RSA process, each of which had been subject to a response by the access designer, and each response had then satisfied the RSA team and of course the council itself. The first issue was in respect to the swept path analysis. Mr. Whittingham confirmed that the RSA demonstrates that having initially raised an issue regarding the drawings submitted, the RSA auditors considered the response and the drawings, which established that a 16.5 metre articulated vehicle and the more standard 10 metre 20-tonne rigid vehicle expected to use the site can indeed use the access within the tolerances identified. As Mr. Whittingham conceded, the RSA auditors confirmed quotations confirmation that the majority of vehicles that access the proposed minerals extraction site will be a 20-tonne rigid vehicles which can manoeuvre safely at the proposed junction, and that articulated vehicles will not be regularly observed, but can be accommodated, address the road safety concern at this stage. Mr. Whittingham then suggested he was simply offering his different view, but it's not based on any proper analysis of the drawings which show exactly what the RSA auditors have confirmed. And in any event, Mr. Howard confirmed that even if there was any remaining concern about the dimensions, the access could simply be enlarged if it were thought necessary. Mr. Howard made the point that it's unnecessary and inappropriate to do so if safe access has already been demonstrated, but one can, of course, readily adjust the access in the detailed design process. Though this is incapable of being a legitimate basis for objection to the scheme anyway. As identified, the process of detailed design will be followed by a further safety auditing anyway, which can proceed up to stage 4 if necessary, none of which was recognised by Mr. Whittingham. This is consequently a completely unjustified basis for criticising the proposal. The second issue that was originally raised was the location of the pedestrian and cycling crossing point within the junction. This too was subject to a detailed designer's response set out in the RSA report in blue text. As explained by Mr. Howard again, one could simply relocate the pedestrian and cycling crossing point further into the junction itself, as originally suggested, if necessary, and direct pedestrian and cyclists to that crossing point within the railings. However, the proposed arrangement was indeed safe, as the auditors themselves recognised It's understood that following the updated rules of the Highway Code, driver/rider following traffic is turning into a side road should expect to wait behind a vehicle giving way to pedestrians and cyclists. The likelihood of an HGV arriving when school pupils pass is slim. Relocating the crossing point away from the design is contrary to the guidance on the design of cycle infrastructure detailed in LTM 120. Accordingly, they said the risk that remains is one which exists at the majority of junctions that observe HGV traffic. That, of course, sir, includes those that already exist at Hamble Lane, for which there's been no incident. Again, as explained by Mr. Howard, this can't be a basis for refusing permission, as the junction can be relocated further into the site in the detailed design if that were considered to be required for safety reasons, which it is not by the RSA auditors or the council. In the course of giving evidence, Mr. Whittingham purported to express a concern that as to a total distance, a pedestrian and cyclist would be crossing the junction about 12 metres in 2 stages. But that concern proved to be objectively without foundation. It's clearly not a concern from the RSA auditors or the council, nor does it have any empirical basis. First, the crossing of the junction is in fact staged with the existence of the pedestrian and cycling refuge in the middle with all necessary safety rings. Secondly, with that refuge, pedestrians and cyclists are only crossing a road with movements from one direction at any one time. That contrasts with the position at the BP oil terminal at Hamble to Rice, which no one has suggested is unsafe. There, pedestrians and cyclists already cross a full 12 metres of a junction, taking HGV vehicles entering and exiting without a safety issue arising. Third, Mr. Wickham was unable to point to any technical standards or guidance to support his claim that the junction with the pedestrian and cycle refuge island proposed was unsafe. Fourth, Mr. Whittingham purported to express a concern about a pedestrian or cyclist having to look over their right shoulder when travelling south, but this makes no sense. For disjunction arrangement, that's the only direction that a person needs to look to make the crossing to the pedestrian cycle refuge island. It's no different to any other junction, including that for Ensign Way just to the south. By contrast, if crossing the BP oil terminal, a person has to consider traffic coming both ways. But the reality is that the RSA auditors and the council have identified such manoeuvre is a safe one. It's a feature of such environments, and there's no basis for suggesting it's inherently unsafe. The third issue in the RSA report was simply a recommendation that deterrent paving be included in the junction arrangement beside the proposed guard railing. And as recognised in the response and then the auditor's reply, such deterrent paving can be provided and will be further considered in the detailed design, which addresses any issue of road safety concern. The criticisms of the WCHR were unfounded, as Mr. Howard dealt with in his rebuttal. Finally, Mr. Whittingham on this heading sought to refer to objections from the Police and Crime Commission, the fire services and the schools. I've already noted it's unfortunate such bodies have misunderstood the proposed development and its traffic implications, and HPGG and Mr. Whittingham have clearly not helped in their serious mischaracterisation of the position, whether in terms of perpetuating the myth that the traffic modelling is not based on representative data, or in seeking to suggest that the site access arrangements have been heavily criticised by the RSA auditors. It is perhaps little wonder that people have such a distorted but incorrect view of the scheme when faced with such misinformation. But as explained by Mr. Howard, the objections from local services, including the police and fire services, are unfounded on any objective analysis of the effect of the proposal on the highway network. Come to the impact in a moment. Blue light services necessarily have to address existing traffic congestion on Hamble Lane in relation to daily vehicle usage, including HGVs. The proposed development is not adding any unacceptable increases to those existing flows. Blue light services will continue to negotiate the traffic, including any congestion, in the same way that they do now. Moreover, there's been a complete failure to recognise the fact that the proposed development provides the contribution to enhance Hamble Lane for pedestrian and cyclists in the scheme identified by the council for the benefit of existing residents and school children alike, not just for the temporary duration of the extraction, but permanently. Then turning to the impact on the road network, this was the final issue raised by HPDG and local residents, given that Hamble Lane is a busy road that experiences congestion at peak times. That, of course, is why the opponents have conducted such extensive analysis, far beyond that which could reasonably be expected, and it has been subject to rigorous testing by the council. For these purposes, the appellants use that extremely robust methodology of 144 HGVs, even though 126 are proposed. It's ignored for this modelling the effects of limiting existing traffic during the peak hours. It's used the highest levels of traffic from the 22 data and not sought to reduce it for 24 and 25 data. It's modelled junctions all the way up Hamble Lane, something that no development has ever done. It's examined the effects of the traffic at the busiest time, peak hours being agreed with the council, because of course traffic flows outside those times will inevitably progress. Even using those extremely robust assumptions, the appellants clearly demonstrated to the satisfaction of the council there will be no severe impacts on the highway network as a result of its traffic. One, of course, has to remember that proposed development is inherently temporary in nature. Although present for a number of years, the HGVs will only be present for that extraction and restoration. Thereafter, the movements cease. This is a feature of mineral extraction, namely minerals can only be extracted where they're found. But once extracted, the site can be restored and the activity will no longer be there. That, of course, is in stark contrast to ordinary forms of development, such as retail, employment, or residential, where traffic impacts are permanent additions to the network. The resulting data from the modelling set out in the TA addendum, but fully summarised in Mr. Howard's proof of evidence, it demonstrates the effect of the imposition of the 45-minute restriction between 8 o'clock and 8:45 and 2:30 and 3:15 as a further measure to address the concern regarding the use of Hamble Lane during those busier times for schools. And the appellant has already demonstrated the safety and acceptability of what's proposed without such limitation, but also demonstrated that the use of this restriction will further limit activity in these periods, which represent the time when there is the greatest concentration of school activity on Hamble Lane in the vicinity of the appeal scheme. The appellant has gone out of its way to respond to those concerns of local residents, even though the analysis of the model demonstrates such additional limitations are not strictly required. Objective analysis of the resulting data quickly explains why the council are unsurprisingly satisfied there is no unacceptable impact created by the development, even assuming such extremely robust, more than worst case assumptions of use. All the model junctions reveal very limited effects of the peak activity, with average delays of only a few seconds in the peak periods being created. Such additions will of course not be perceptible in reality, being lost, as Mr. Howard fairly identifies, in the daily fluctuations of traffic that will be experienced in any event. This is anything but severe, as the council have fairly recognised, see the statement of common. Not content with that objective appraisal, HPDG and Mr. Whittingham pursued those criticisms of the data for the modelling, which we say are unfounded for the reasons set out above. They also placed particular reliance on the inspector's decision for the GE aviation scheme from 2021. As explored in evidence, this is misplaced for a number of basic reasons. First, the inspector was considering a proposal for residential development of 148 dwellings. Such development is intrinsically different to the mineral extraction proposed here. Such development is permanent. Any traffic impacts remain in place in perpetuity. By contrast, mineral extraction is temporary, and in addition, the traffic modelling for the mineral extraction is based upon a peak of activity, here 4 years only, as we were using numbers of HGVs that will not actually take place. That's the 144 again. No such robust approach featured or would be expected in the GE aviation scheme, where the activity would persist in perpetuity. Secondly, residential development is inherently footloose in contradistinction to minerals development, which can only be found. Housing is not so limited. Thirdly, the inspector was considering a proposal for an unallocated residential development on that site in circumstances where there was indeed a council presumption against allowing additional development in the area, in distinction to the allocated mineral extraction here, which is not subject to that presumption. Fourthly, the inspector was considering the development in a context where it was still anticipated there would be road improvements to Hamble Lane at some point, but which were not being delivered by GE. By contrast, no such road improvements are now being pursued by the council, but rather a different approach of encouraging modal shift to reduce demands on the road, in line with the approach in the latest framework. Fifth, the inspector's particular conclusions as to what he regarded as severe impacts on two particular junctions, the Tesco roundabout and the A3025 Portsmouth Road Hamble Lane junction, were based upon modelling which showed existing congestion at that time to be significantly greater than is now the case. So, for example, the Hamble Lane Portsmouth Road junction, the inspector was dealing with an existing delay of 3 minutes being increased to 3.5 minutes by the scheme on a permanent basis. By contrast, the position here is that the delay at that junction is shown to be 114 seconds, which would increase to a maximum of 140 seconds, but on average only by a few seconds. Accordingly, even assuming a maximum delay created by the proposed developments using an unduly pessimistic 144 HGVs, the overall resulting delay is significantly less than the delay the inspector was considering as the baseline at the time of the aviation appeal. There is simply no equivalence in the analysis, even before one takes account of the other differences already identified. And of course, there's no identification in the GE Aviation case as to the average delays that were an issue, which the appellant has identified for the scheme here, the resulting few seconds that will be experienced. Sixth and finally, the invocation of the 2021 decision is of course highly selective and ignores the later inspector's decision from 2022 dealing with Satchel Lane, where the inspector considered that delays of less than 10 seconds in this locality would not be severe. Mr. Howard's also gone on to consider in detail the overall effects of the additional traffic and pedestrians, cyclists using Hamble Lane in terms of the number of existing vehicles, including HGVs, they would experience, as compared with the very modest increase that would be experienced on the same journey, assuming the proposed development operating at its peak. As he fairly pointed out, and no one's challenged him in his evidence, a pedestrian undertaking a 15-minute journey on Hamble Lane, such as travelling to school, currently be passed by around 5 HGVs and around 370 other vehicles. In the future, assuming the proposed development operating at its peak, the same pedestrian would be passed by an additional 2 to 3 HGVs on the same walk and around 375 other vehicles. This is in circumstances where the existing traffic has resulted in no accidents with HGVs on that stretch for the past 10 years. And a cyclist undertaking the same length but a 5-minute journey would be passed by 1 HGV, 25 other vehicles. With the proposed development operating its peak, that would increase simply by 1 further HGV. This is reflecting the reality of why such increases in traffic, even assuming more than the worst case, cannot rationally be described as unacceptable, severe, or otherwise detrimental. So without repeating all the results of the modelling, we have absolutely no hesitation in commending that analysis by the appellant's expert and that of the council. It has been demonstrated using the most robust analysis there will be no unacceptable impacts on the highway network for that temporary period that the proposed development's in place in order to extract this important mineral resource in the public interest. Turning then to the mitigation and the contribution to be provided to the improvements on Hamble Lane, as is emphatically clear from the Statement of Common Ground, the results and the results above, such mitigation is not required, being offered in order to mitigate what would otherwise be any severe impacts on the network. Those such severe impacts would arise. To the contrary, the mitigation is being offered as being necessary to achieve the policy objectives of improving the road network in accordance with the Eastleigh local plan. Even without such measure, the proposal will clearly be in compliance with the more up-to-date NPPF. This would clearly justify the grant planning permission anyway. There's been much debate at the inquiry about the mitigation proposed in terms of deliverability and cost. That debate's not been merited, although the appellant is certainly keen to ensure that the benefits of this mitigation are not overlooked in the dust thrown up by the HPDG. As to deliverability, both the appellant and the council have identified very clearly the principal elements of what's proposed in the drawings attached to the Statement of Common Ground. It's always been the case for such schemes that the detailed implementation of the improvements will be a matter of detailed design by the council. But as demonstrated very clearly by Mr. Howard in his rebuttal, various components of the improvements to the pedestrian cycleways along the affected sections can be delivered in a number of different ways. It's particularly unfortunate that HPD's objection in this regard appears to be based on the supposition that if one cannot, for example, deliver an enlargement to a shared path of 3 metres throughout its whole length along Hamble Lane, because, for example, the existence of a tree causing some very localised narrowing, that means the scheme is undeliverable or somehow should not be delivered at all. That's both unrealistic and obstructive in principle. Mr. Howard's photograph at image 1.3 of his evidence shows what is obvious. People currently use the substandard parts. Widening them to improve them would be a demonstrable benefit. It's clearly wrong to suggest no improvement should be delivered if they cannot reach the guidance requirements of LTM 120 for their whole length. Mr. Howard similarly presented the options for improvements along all of the affected parts of Hamble Lane, including in the vicinity of the allotments. Again, those improvements can be delivered alongside the carriageway without using land immediately adjacent to the allotments if that is the preferred solution. But the land running alongside the allotments could also be used if thought better, although clearly the allotment holders would not favour that solution. But these are matters for detail for the council in due course. The principle of deliverability is clear. Again, the fact that such improvements may continue to include some local narrowing does not affect the fact that significant improvements will be obtained. Perhaps unsurprisingly, the local community's perception of this mitigation is coloured by its objection to the scheme itself, rather than focusing on the benefits of the mitigation if the scheme does indeed go ahead. As to costs, it's extraordinary that this has prompted such a level of debate at this stage of the process. This is all turned on a misreading of a reference to a figure of 200 metres in an HCC response document, to the effect that it said that the costings were only carried out assuming improvements to 200 metres. The councils confirmed that was not the case, yet HBDG seem unwilling to accept this. It's not clear why, but the attempt now to suggest that the costings are incorrect make no sense at all. First of all, the appellant's own consultant has now carried out a costing of what's proposed, demonstrated it clearly can be delivered within the £500,000 contribution sought. Indeed, that includes 40% of contingency in the budget. Secondly, the council itself has confirmed that it's costed the improvement similarly and similarly satisfied it can be delivered for that sum, again with a very large element of contingency. Third, as you requested, the SPOM's costing of the basic quantum of what's being suggested clearly demonstrates that such amounts of improvement can obviously be delivered for such a sum. Indeed, there's a huge surplus to deal with the other elements of the scheme. Fourth, despite all of that, Mr. Whittingham has belatedly now sought to put in his own costings to suggest the sum is more like 1.2 million. Just note that wasn't what you actually asked for in terms of detailed costing, but he put it in anyway. No such costings were put in before. They don't reflect the reality, with artificially inflated costs included. And as an example, he includes 177,000 for new street lighting and ducting along the length between the railway station and the Hamble rail trail. But this section is already lit. His allowances for TM preliminaries and contingency then unnecessarily inflate this expense by a further £145,000. Of course, the ridiculous thing about all of this is that the council has absolutely no interest whatsoever in undercosting the scheme anyway. If it believed it costs more, it would simply have asked for more. We therefore commend to you the agreed position between the appellant and the council as the body responsible for delivery of the mitigation itself, that it can indeed be delivered within the sum sought. There is no objective reason to think otherwise. The reality is the proposed development will enable the delivery of these improvements to address existing conditions for the significant benefit of all, not just for the development, duration of the development, but in perpetuity. And taken with other connections created for pedestrians at the appeal site itself, any fair appraisal would recognise the significant benefits the proposed development will actually secure for pedestrians and cyclists in this area, and the essence of positive sustainability that the proposed development will be promoting for all. So for all those reasons and the detailed evidence and the common ground, so we say there's no basis for objecting to the scheme on highway grounds. To the contrary, the policy is not only acceptable in policy terms, but will deliver significant benefits by way of the mitigation scheme, which will be of lasting improvement to the local area. I turn to habitats and hydrology and recreational pressures.
Just at that point, I have an hand raised by Mr. Fulbrook, which seems a good point to take a break if that's what you're requesting, Mr. Fulbrook.
It was, if I may, sir, simply just we've been sat for 2.5 hours, and obviously at this rate there's a little bit more to go, so I would be grateful for a short comfort break. Okay,
it's we're over a third of the way through. I think Mrs. Strawn's closing submission, so it's 16:37. We're all in relative close proximity to facilities, I think. maybe not for the council, but I'm sure it's not too far. If we take a break there and come back at 16:45, I would recommend people remain connected. I will turn my camera and microphone off. So we'll take a break at that particular point. We'll come back at 16:45 and we'll recommence closing submissions with the HRA, the hydrological and recreational pressures sections of Mr. Strong's closings. We'll take a break there.
Thank you, sir.
That's now resumed, sir.
Thank you. Okay, it's now 16:45. The inquiry is now resumed. We paused at the end of paragraph 87 of Mr. Strawn's closing submissions. We'll now resume with the Habitats Regulation Assessment, Hydrology and Recreational Pressures, starting at paragraph 88. Mr. Strawn, please proceed.
Thank you, sir. Now that the HPD withdrew objections on veteran trees, there are these only two other issues concerning HRA in relation to hydrology and recreational pressures on the National Sites Network or National Network sites. The legal framework set out in Regulation 63 of the 2017 regulations. Regulation 63 has been the subject of considerable jurisprudence with some very well established principles which we say HPDC has sought to sidestep. We refer you to what Keith Lindblom said in the Wyatt case, and we set it out in full in a footnote, which I'm certainly not going to read that, but you got there, as to what points emerged. There are two elements to Regulation 63. First of all, consideration of whether there's a likely significant effect. If there isn't such an effect, there no further assessment is required. And secondly, if it is likely to have a significant effect, then an appropriate assessment needs to be carried out on an adverse effect on integrity on the site in light of this site's conservation objectives. So in respect of the application, the Council assiduously performed that exercise when its capacity as competent authority at the planning application stage after statutory consultation with Natural England and in light of the expert information compiled by the appellant at the application stage. And we refer you to the Council's own HRA, which Natural England has endorsed. You are now the competent authority, but it's now established at the highest authority that you may not only rely upon the views of Natural England, where it's satisfied itself there will be no such adverse effects, but you're entitled to presume no such adverse effects in reliance upon that assessment. And you have to have cogent reasons for disagreeing with the Natural England Sea Morge. The Council's own judgment in its HRA relied upon Natural England's assessment, which could have only been challenged on Wednesbury grounds, which would have presented a very high threshold where Natural England had withdrawn its objections. And as we identified in opening, the reality is there's simply no basis for suggesting there would be any adverse effects on the integrity of the protected sites for the reasons given in the appellant's shadow HRA, the addendum HRA, and the Council's own HRA, and Natural England's full consideration of those documents and satisfaction as to the absence of any such adverse effects with the embedded mitigation proposed. Not only have the Council satisfied themselves of that, but also that process has been endorsed by Natural England. The reality is there's simply no basis for suggesting there would be adverse effects for the reasons given in those documents. And so, also now the evidence from Dr. Dewis and Mr. De La Haye. In short, there is no material change to the and can I just emphasise the word material change, because my learned friends' submissions are all predicated upon an artificial notion that if there's any change whatsoever, it must mean that there is some material change, which is clearly not the case. I'm just adding that definition. But there is no material change to the hydrology arrangement proposed in consequence of the extraction and restoration, having regard to the drainage strategy and the nature of the operations. There is no effect to the water environment of the protected sites anyway. But even if there were any change to the water environment, it's simply not capable of affecting the protected sites in terms of their designation and features, as they do not depend in any material way for the site and its fresh water. So could I just ask you to note here one other reference in response to my learned friend's submission. Our shadow HRA, page 17, CDB 79, which Natural England has clearly had regard to in reaching its conclusions. The likely significant effects for hydrology were ruled out, as he puts it, because the river Hamble, this is the words in the document, is influenced by tidal input from the Solent and freshwater inputs from upstream. At this point, it is not dependent on groundwater to maintain flows. And secondly, it's simply fanciful to suggest that there would be any material additional recreational pressure on protected sites as a result of the proposed development taking place, let alone pressure that would adversely affect the integrity of the protected site. One of the embedded mitigation measures is the creation of the permissive path with a dedicated landscape area through the site, protected site operations by bunds, which will be in place at all times during operation. It enables a walk of over 2.1 kilometres in a landscape area where people can walk with dogs off the lead. And it will not only be a new permissive path designed as such, which doesn't depend upon the current unauthorised use, but it will link up with the extensive areas of existing recreational opportunities that prevail throughout the area. That will then, in due course, be supplemented by the new meadow area on restoration. We see any walk around the various trails available within the Victoria Country Park immediately demonstrates how absurd it is to suggest that displacement activity from the appeal site, even if it were to occur with the permissive path in place as we identified, would somehow lead to displacement that adversely affects the integrity of the protected site, given the full extent of the opportunities available in the area. HBDG's case is pursued in the face of Natural England's complete satisfaction as the absence of adverse effects, and the attempt to suggest that it was somehow affected by resources has proved to be as unsubstantiated as it is fanciful and disrespectful. So, notwithstanding the absence of any compelling reasons on the face of the materials to depart from Natural England's views, I just set out analysis of some of the evidence that was heard on the topics, which confirms why the HBD position is unsupportable. On hydrogeology, despite that complete satisfaction, the HBDG attempt to pursue an objection on the basis that there may be a potential likely significance. The assertion made in their statement of case is that there remains reasonable scientific doubt that the development would have an adverse effect by reason of hydrological impacts during operations and in the final proposed state. Although such a broad assertion is made, it's relevant to understand exactly what HBG necessarily has to be suggesting to understand how misconceived the assertion is and how contrary to all the evidence presented. As Dr. Dew has correctly analysed, it involves a series of misconceived assertions, each of which are dependent on each other, each of which would have to be made out. First, there is an assertion that extraction of the sand and gravel in the river terrace deposits on the site and use of inert fill will materially affect the quantity and timing of flow to certain springs off-site. And second, there is an assertion that any such change to those springs will materially affect the freshwater environment of the national site networks and likely significant effects and or potentially adversely affect those sites. The first assertion is a matter of hydrogeology, dealt principally by Dr. Dewhurst, and the second is a matter of ecological assessment, then principally by Mr. De La Haye. I'll deal with them in turn. But viewed holistically, this is a classic example of contrived objection in the face of all the scientific evidence. Leave aside the detailed scientific appraisal the appellants undertaken to demonstrate there won't be any such effects, and Natural England's own complete satisfaction that there will not be any such effect, likely significant effect at all, it is obvious that there is no likelihood of such effect. The proposed development during operation and then following restoration has been specifically designed to mimic the existing hydrological flows from the appeal site into the surrounding area. And those existing flows are, of course, completely inconsequential in relation to the national network sites in any event, which represent vast tidal water bodies that are not dependent on the spring flows or the appeal site anyway. I just repeat that reference I gave to you in the Shadow HRA, page 17, CDP 79, on which Natural England are clearly informed. The development proposal's been subject to the most intense scientific scrutiny in this regard, which has been reviewed by the Council on Natural England. There's a huge range of material as summarised by Dr. Dewhurst in paragraph 1.4, and giving you the references. The first assertion as to the flow effects The existing hydrogeological setting and assessment is fully explored in the accompanying material. It was addressed in evidence by Dr. Dewhurst, and no material challenge was presented to her assessment based as it is on extensive scientific data. Indeed, Dr. Clothier in cross-examination accepted that the appellant's baseline assessment is a far more detailed assessment of the appeal site than Dr. Clothier's assessment in his section 5, as the appellant had a lot more data. It's unnecessary to set it all out here and the underlying material. Neither HBG nor its witnesses have challenged what is in her identification of her evidence at paragraph 4.1.2, but in short, the appeal site's location on the peninsula between River Hamble and Southampton Water, and it's those water bodies that are part of the SAC and SPA issue. Both rivers are tidal in the Hamble to Rice area and drain significant river catchments. And you've got the areas of concern, vast areas of concern. The appeal site represents less than 0.2% of the freshwater catchment feeding those water bodies. It's a tiny area. And the contribution of the springs to the River Hamble of concern is less than 0.1% of the flow of the River Hamble itself, as objectively verified by the frog mill flow data Dr. Dewhurst gave. The springs in issue sit within that local surface water catchment, which drain towards the springs in issue sit within the local surface water catchments, which drain towards those bodies, I should say, rather springs, as presented in figure 8.22 of the ES and the drainage drawings, reflecting the baseline surface water catchments. It's accordingly intended to mimic those existing conditions. The appeal site underlain by the river terrace deposits and below that by Marsh Farm Formation, Erling Sand and Selsby Sand formations, but where the ground investigations reveal more of the latter than the former predicted by the British Geological Society. These other underlying layers are considered to be secondary A aquifers, permeable layers capable of supporting water supplies. And Dr. Clothier conceded in cross-examination he had wrongly treated and built up his own conceptual model erroneously on the basis that such layers are aquicludes, i.e. exclude water. Accordingly, his own conceptual model and conclusions are built upon this basic fundamental error. That led him on to the clear error that the springs in question are only being charged by groundwater from the river to terrace deposits, when that is obviously not the case. The appellant and its experts have undertaken extensive ground investigations and monitoring of water levels on the appeal site between January 29 to April 23. They've got a wealth of scientific data covering a range of seasonal conditions to underpin that hydrological assessment. Again, contrary to Dr. Clothier's treatment of geology, both the river terrace deposits and the other geological layers show responses to rainfall recharge, that the other geological layers, referred to as solid deposits, remained wet when the river terrace deposits, referred to as superficial deposits, were dry. There's the existence of a vertical gradient from groundwater from the superficial to the solids. As identified in the technical note identified in the closing, the appellant's assessment establishes that the springs receive some groundwater and surface discharge from the appeal site, but infiltration testing is taken place across the appeal site to establish the varying infiltration rates for water falling on the river terrace deposits in the centre of the sites, which would generally be at the boundary some 400 metres away within a few days. The range of rates and times is reflected in the evidence, allowing one to calculate a flow of approximately 0.5 to 3.5 metre cubes per hour and an average of 3.6 metre cubes per hour. And can you just note, sir, that it's therefore absurd for the appellant in closing, yet again, simply to use the extreme end of 1 year for a raindrop in the centre of the site to reach the edge. Turning then to the effects of the operation and restoration in terms of water management, that's been thoroughly examined by reference to that extensive analysis. It became very clear that HBG and Dr. Clothier fundamentally understood what's to occur during operation and restoration. As summarised in Dr. Dewhurst's evidence, section 5, and again not substantively challenged, the operation involves extraction of the river terrace deposits, but not the removal of the underlying layers of geology which do act as aquifers, not aquicludes, as wrongly assumed. The operation is carried out in stages, with each area undergoing restoration progressively. The screening bund will be constructed around the appeal site on top of the underlying permeable river terrace deposits, which will not be extracted, with restoration drainage features installed sequentially. The work phases are identified, and that identifies when any possible effects on flows to springs and which springs. During that operation, it's not expected that any dewatering will occur, as the minerals will be extracted dry or wet where they are found. But if any dewatering does occur, the water will be immediately recharged into the adjacent area of unworked ground. Contrary to what Dr. Clothier and Mr. Andrews believed, water is not pumped to the lagoons and discharged elsewhere. Lagoons only deal with the water on the processing area. The revised restoration plan ensures that the post-restoration contours of the appeal site will mimic the flows for the original catchments. It means that the same flows of water will head to the same springs that currently exist. The revised restoration plan is designed to ensure that the water infiltrates into the surrounding area at the same rate and in the same locations as those which currently exist on the appeal site, taking full account of the presence and infiltration rate of the AEGB, that barrier for the inert fill that lines the voids for the inert restoration material. See Dr. Dewhurst's evidence. Runoff from the areas of infills then captured in the attenuation basins and discharged to ground within infiltration features located on the undisturbed river terrace gravels at the outer parts of the appeal site, with soak away controlled by the natural ground conditions that are unchanged in that area, with water held in the drainage features until it soaks away, so making it unlikely that this will change the timing of any flow to the springs in any event. See her evidence. Again, just note that is not evidence which Mr. Fulbrook cites in his closing. The drainage is based on micro drainage calculations and robust and industry-wide established system for calculation, as Dr. Clothier accepted in cross-examination. If there are no material changes in flows, there will not be any effects on the protected sites. The proposed development and supporting assessments have therefore fully accounted for any potential impacts to flows off-site in the operation and subsequent restoration of the site in accordance with the restoration drainage design. In that respect, Dr. Dewhurst has correctly pointed out the application and supporting material has done exactly what was anticipated in the HR record appendices for the existing plan, along with the partial update of carrying out a project-specific HRA. It's also important to note the partial update already recognises that the hydrological assessment that's been carried out in support of the proposed development and reviewed by the council, and it recognises, there are no surface water features within the footprint site, and there are no surface water links from the site to the River Hamble. Secondly, the River Hamble is influenced by tidal input from the solent and freshwater inputs from upstream. At this point, is not dependent on groundwater to flows. Given the scientific analysis that's been done, which demonstrates exactly that point, the conclusion is entirely unsurprising. The nature of the operation and restoration ensures there'll be no material change, let alone any significant change, to the groundwater flow to springs in the vicinity of the appeal site, which in turn discharge into the relevant water bodies. But in any event, it's blindingly obvious that any such flows from those springs into the water bodies are insignificant to the fresh water in those bodies. So it's clearly absurd to suggest, even if, which is not the case, the scheme did have any material effect on the flows to the springs themselves, that any such effects would constitute a likely significant effect on the national network sites, let alone an adverse effect on the integrity of them. As Dr. Dewhurst confirmed both in her rebuttal evidence and orally, even if discharge from the appeal site to the springs and the spring discharge were to cease altogether, which is not what's going to occur, it's extremely unlikely that the effect would be significant in the context of the wider protected sites. And that, of course, is entirely consistent with the partial update plan HWMP habitat regulations assessment analysis as cited above. The lead local flood authority clearly have scrutinised the hydrological conditions. That led to the first reason for refusal of the application originally, though that was capable of being addressed by the restoration plan. That's been done by the revised restoration plan, which now mimics the existing conditions on site. See the technical notes which fully address those issues. More fundamentally, Natural England has itself satisfied itself of the position, specifically in this context, He'd asked about any potential impact on triple size. Dantec responded to that letter, demonstrating that the proposed surface and groundwater management during operation and restoration would not cause any such impact on the national network sites. Consistent with what Dr. Dewhurst has identified in her evidence, as a basic starting point, the flows in the springs identified off-site, which APG makes various assertions, are obviously very small in terms of flows into the national network sites. Groundwater from the river terrace deposits on the appeal site is likely to be limited seasonally anyway, as shown in the borehole data, which exists over a number of years. So, for example, in summer periods with little rain, it cannot be water in the river terrace deposits that's feeding the springs in the surrounding area anyway, because they're dry. But the deposits are dry. Flow times through the appeal site to the springs is likely to be days and months, limiting discharge of groundwater to those springs for any prolonged period after rainfall. In the operation period carried out in phase stages, there's a notional potential to have some impact on the flows to the springs, but these will not be material impacts, given amongst things the lack of groundwater in the river terrace deposit seasonally, and in any event, the planned recharge of any groundwater removed from the extraction voids into the ground adjacent to any extraction, along with the staged extraction and restoration which is to occur. In the restoration period, the design has been deliberately provided to mimic the current drainage of the appeal site, both locationally and in terms of flows, so preventing any long-term impacts on the springs and certainly ensuring they could not be significant. So can I just ask you to note again the appellant's closing submission suggesting Dr. Dewhurst has made some surprising or astonishing admission that the hydrograph may not be exactly the same, but obviously clarifying, making clear that it makes no material difference to her evidence. It's not exactly the same. It's entirely consistent with all of the evidence she has given, and the appellant is seeking to create some point out of that, what described as an omission when it clearly is not. So back to the text, all of this is before one even gets to the second and third assertions in HPD's case. Even if all of that was somehow wrong and any impacts on the flows to the springs, of course, is not capable of having any likely significant effect on the national network sites. And even if capable, it couldn't potentially have any adverse effect on integrity. With that in mind, we turn to some of the serious errors made by HPDG in seeking to suggest that any of this assessment is somehow invalid or not following a precautionary approach. And of course, one's simply dealing with the first assertion here, that namely any material impact on the flows to the springs in question, before turning to the other assertions. The reality is that the case from HPDG and Dr. Cloder are based on some fundamental errors and misunderstandings. The purported criticisms are not based on any modelling work, and they do not contradict the extensive scientific data modelling that's been produced by the appellant and its experts. Dr. Cloder accepted that modelling data could have been challenged, but he was not doing so. It's also important to remember that even to get off the ground for this flawed challenge to the evidence, that one has to be looking at the flows of the springs to the national network sites. And if, as is the case here for the appellant's experts, EA, Natural England, and the LFA, and the Council, they're all satisfied there won't be any such material or likely significant effects on the flows themselves. There's simply no basis for suggesting that there's been any non-compliance with the HRA. The first assertion by HPD was a contention that during operation, the eastern springs would receive and carry less fresh water that is relatively pure, and the western spring would receive more. It was poorly asserted this would lead to a reduction in fresh water and consequently dilution of salinity and nutrients in the River Hamble and increased dilution of nutrients in Southampton water. The starting premise is flawed. For the reasons explained, there would be no material impact on the flows in the River Hamble and Southampton water. Although one may have a notionally different curve in the hydrograph of flow as a result of recharging the water during operation in the adjacent ground and or after restoration by recharging happening through the infiltration facilities, Dr. Dewhurst was absolutely clear that any such change would be immaterial. It is unnecessary to model it. As a result of the way in which the site will be operated in a staged way and the recharging of any water extracted, it's obvious Dr. Dewhurst is correct. Any effect on the timing and location of discharges to the springs will simply be insignificant. This is in addition to the fact that extraction will not be occurring across the entire site at once. And of course, there is a lack of continuous groundwater in the river terrace deposits seasonally anyway. The contention to the contrary, or simply an attempt to cast doubt, is based on a pure assertion that fails to reflect the operations that are planned. Any groundwater that's disturbed on the site during extraction will be recharged into the appeal site and recharged through the ground, through the natural soils and undisturbed river terrace deposits that are not being worked on restoration. The same will happen with the drainage arrangements on restoration, controlling the soakaway with the infiltration features. There's no basis for suggesting there be any likely significant effect on such flows in the first place. Secondly, even if there were any impacts on flows, there's no basis for asserting that it would have any likely significant effect on the sites anyway, given the relative size of the appeal site, the discharge volumes which have been robustly calculated, and the fact that the springs represent an insignificant flow to that catchment. As HPG now accept, the springs are already fed by groundwater which doesn't exclusively come from the river terrace deposits. As Dr. Dewhurst proved from the borehole monitoring, there are significant parts of the year when the river terrace deposits on the appeal site are simply dry. Accordingly, the springs and any flows to the national network sites will already experience significant periods where no groundwater comes from the river terrace deposits anyway. No one suggests, nor could they reasonably suggest, that this creates some sort of adverse effect to the protected sites, whether in terms of nitrate, salinity, or anything else. The second assertion in the statement of case is as to a potential effect based on the restored site's permeability being less than the current site due to the presence of the inert fill and membrane. That makes no sense in light of the scientific assessment and mechanisms in place. Dr. Dewhurst confirmed, and the supporting material demonstrates, the lower rate of infiltration for the infilled area as a result of different permeability has already been taken into account in the revised drainage design, and the design reflects that. The resulting design and infiltration to mimic restoration contours, surface water catchments, and corresponding infiltration rates through the natural strata. Accordingly, discharge to the ground and consequential flow to the springs will occur at rates which will not materially affect the current position. Any slight location in the location and timing of the recharge as a result of the scheme will clearly be insignificant given the established lack of continuous groundwater flow from the river terrace deposits, reflects the existing position as proven by the borehole monitoring, and the use of natural soils to control the soak-away and filtration features. Moreover, any losses to evapotranspiration from the attenuation and infiltration features themselves will be insignificant given the size of the features to the size of the appeal site. The third assertion is to the assertive loss of flows, which would be immaterial anyway, that this would somehow affect the hydrology and water quality of the network site which the springs flow into, with an assertion that it would potentially reduce the dilution of nutrients in the river Hamble. I'll deal with the ecological effects separately, but the hydrogeological assertion is demonstrably absurd and unscientific on any basis. The appeal site represents less than 0.2% of the catchment into those water bodies, and no one's challenged that evidence. The flows from the springs into the national network sites are tidal in the location in question, inundated by vast amounts of seawater twice every day. It's therefore simply nonsensical to suggest that even if the flows from the springs were materially affected, which isn't the case, that could have any effect on dilution or nutrients. There's absolutely no supporting evidence provided to support such an assertion. Indeed, as Dr. Dewhurst points out, the nearest river flow gauging station at Frogmill, 18 miles upstream, indicates a mean freshwater flow 1,800 cubic meters per hour in the river. So the spring flows, even on the most precautionary basis, are in fact less than 0% of that flow. But there's no basis at all for asserting there would be a complete loss of spring flows from the appeal site to the springs anyway. During both operation and in restoration, recharge to the natural ground to those springs is an inherent part of the design. Any variation of flows from the appeal site into the springs in terms of an altered hydrocraft would necessarily be a far smaller percentage, even if it were to occur at all, and simply be even more inconsequential in terms of flows into the Hamble anyway.
The fourth assertion made in paragraph 48 of the Stoneleigh case is to complain about the fact the council's HRA screened out any appropriate assessment being required on the basis of the Environment Agency response. That's followed by assertions that the appeal scheme concentrates groundwater ingress and spring flow into a short time frame, or eliminates long-term storage in sands and gravels, or risk altering seasonal trickle of spring flow, particularly during summer months. Each of those contentions is misconceived for the reasons already addressed in large part, as Dr. Dewis explained, amongst other things, by reference to the scientific data. There's simply nothing in the appeal scheme designed to support an assertion the scheme will concentrate groundwater ingress into a short time frame. To the contrary, the infiltration features for the appeal scheme are positioned on unaltered natural ground, a position where they will provide recharge into the same spring, and the infiltration rates will be controlled by those natural ground conditions. And the attenuation features will ensure that the flow is similar to the current position and elongated to mimic seasonal flow. She also correctly points out any changes that would occur would be insignificant, and even if they did occur, would only be likely to the extent the period of recharge, so not abbreviating but extending seasonal trickles, contrary to what's incorrectly asserted by HPDG. The notion that the removal of sand and gravels eliminates long-term storage is also misconceived, ignores the fact that the restoration scheme specifically includes attenuation points and infiltration to mimic the existing hydrological regime, including that storage, in terms of flows and locations of water off-site. There's no scientific basis for the assertion that the scheme will alter the seasonal trickle of spring flow in the summer months anyway, as already repeatedly pointed out and demonstrated by the borehole monitoring data. The river terrace deposits, which are being removed from the appeal site, are already dry across much of the appeal site in the drier summer months. So the removal of such deposits is incapable of affecting flows to springs in those periods. By contrast, flows in the springs will be supported by other strata in such periods or other unaffected sources. It's therefore fundamentally wrong to assert the appeal scheme is having an effect on such flows, let alone any material, even more vanishingly unlikely, any significant effect on flow. HPDD then seek to rely on what they contend to be the absence of baseline monitoring of the spring flows, but there's absolutely no reason to carry out such monitoring given all of the data and scientifically certain conclusions that have already been reached. Dr. Dewar has pointed out, given the nature of the springs themselves, it would be difficult accurately to quantify the flows within them anyway. More importantly, it's completely unnecessary to do this because the scale of contribution from the appeal sites can be and has been assessed using catchment areas, recharge provision, and groundwater level monitoring exactly the way it's been done. It's entirely unsurprising that the appellant's expert and those of the independent bodies of the EA and Natural England consider this methodology to be appropriate, given the points already identified as the absence of any basis assertion that flows from the springs are material to the national network sites. Dr. Dewar specifically confirms that the impact of changes to spring flow to the national network sites has been assessed suitably to beyond reasonable scientific doubt. It's crystal clear there will be no likely significant effects on such sites as a result of this appeal scheme in terms of hydrology. So there is no requirement to carry out an appropriate assessment of adverse effects on integrity because there are no likely significant effects on them in the first place. The fifth assertion or purported criticism was to question the appropriateness of the micro drainage calculations that underpin the drainage design. That wasn't pursued orally at the inquiry itself, but as explained by Dr. Dewhurst, it's an industry standard software for all such purposes, accepted for use by the LFA, and no issue has been raised by them or by Natural England. The computational engine within the software is based on the Wallingford procedure, widely accepted as the default methodology to use. It's another example of a completely unjustified criticism of the rigorous approach that's been followed by the appellant and its experts in addressing the appeal scheme. The sixth assertion was one seeking to question the hydrological arrangements of Pond 2. That was misconceived because that's only permitted to infiltrate along its eastern face, for which the correct infiltration rate is used given this smaller area, and a kind of consequential conservative assumption has been used for it as an attenuation feature rather than as an infiltration feature. The seventh assertion was one of questioning the FEH hydrology rainfall parameters, and that was addressed in the note that you requested, technical note of 26th of April, which shows that the use of the FHE 22 values are less than in the 2013 data. So the 2013 data is more robust, and the 2022 data doesn't affect the results. The eighth assertion was as to the effect of that the operational phase of the works could affect water availability due to consumption of water for aggregate washing and evaporative losses. That error was repeated in Dr. Clother's proof and repeated in evidence in chief. It was based on the misapprehension of the operations in question. In fact, only 5% of any water in the gravel in fact be lost as a result of retention in the gravel product, the remaining 95% of all water returning to the relevant lagoons and drainage features, and the water being recycled and made available as described. No one has or could suggest that such minimal amounts are capable of having any material effect on flows, let alone any likely significant effect on flows. The ninth assertion was as to the effect of dewatering, and again, water environments were proceeding on a basic misunderstanding of how the mineral would be extracted. In fact, in light of the actual groundwater levels on the appeal site from the borehole monitoring, no material dewatering is considered necessary or would occur on extraction. They'll be extracted wet or dry. They'll be dry for much of the season and then without the need for any significant dewatering. Even to the extent it does occur, the water will be immediately recharged in the way I've described. So the basic premise is flawed. The same point relates to Dr. Clother's misunderstanding as to the role of the silt settlement pond and freshwater pond. His assumption that all the dewatering was being pumped to these locations. In fact, that's not correct. The stage one, the ponds will be constructed. The silt settlement pond will hold water drained from the extracted river terrace porous from that area, providing a recharge into the northeast area of the appeal site. The fresh pond will hold rainwater captured in that processing area. Neither will be taking dewatering from the extraction areas. And generally, if there is any dewatering required in the extraction areas, they'll simply be recharged to the nearest unworked or restored area. Recommendations of the partial update plan. So contrary to Dr. Clother's erroneous assumption, no significant dewatering of any river terrace deposits proposed. They'll simply normally be worked wet or dry as they are found, with any draining that occurs in the processing area resulting in water being returned to the ground, with only 5% loss of water ever occurring. Dr. Clother also confused the very localised dewatering in relation to the network rail assessments for the operation of the mineral extraction generally. Dr. Clother confirmed in cross-examination that his evidence had been written without awareness of the basic methodology for extraction on the site overall, and his evidence was based on assumptions about dewatering, which are simply incorrect. The 10th assertion was a completely untenable claim that the focus of the regulators in managing water was during high-intensity rainfall events, and only for the development in its final state, and an assertion that they had ignored day-to-day flow. Again, it's completely unevidenced, flies in the face of the extensive scrutiny of all the flows by the EA, the LFA and Natural England, as well as the Council itself, including the LFA requirement to mimic existing flows. It is clearly disrespectful to the obvious competence and expertise of those regulators to suggest otherwise. In fact, they have scrutinised both the effects of high-intensity rainfall events as one effect in order to address flooding issues, but have also extensively explored and required adjustment of the hydrological position in all circumstances. The LFA's required revised restoration plan is a potent illustration of the scrutiny that's been applied. The 11th assertion was one where Dr. Clother expressed views on the relative impermeability of the marsh farm formation. Again, that shows a clear misunderstanding of the underlying evidence base. As Dr. Dewhurst pointed out, GI works and the data from them in fact demonstrate the majority of the site is underlain by the more permeable Celsea sand formation rather than marsh farm formation. That's been specifically confirmed by the appellant's infiltration tests. In addition, Dr. Clother compounds this error by treating all of these formations as aquicludes for his conceptual site model, whereas in fact they're secondary A aquifers designated by the agency like the river terrace deposit. They comprise permeable that can support local water supplies and can form an important source of base flow to rivers. As Dr. Dewhurst correctly identifies, where aquifers overlay each other, there's likely to be water moving from upper to lower in any event. The fundamental error made by Dr. Clother in the face of the EA designations to treat the other layers as aquicludes has obviously fed his basic assessment and his whole erroneous model with the hypothesis that removal of the river terrace deposits involves removal of any aquifer layers in the area. That in turn feeds his false hypothesis that springs in the area are only fed by the river terrace deposits. And it's on that false hypothesis that his whole theory flows to the springs will be significantly affected by the removal of the river terrace deposits, when that's obviously not the case. As the investigations and monitoring conclusively demonstrate, hydrographs in the ES show the solid geology layers are in continuity with the river terrace layers and drop below the river deposits. Water levels are low and the river deposits are not continually saturated. Dr. Clothes' errors are multiple in this respect. He wrongly seeks to assert the appellant did not have an illustrated conceptual site model. As Dr. Dewhurst identified, that's simply wrong. The Stantec conceptual site model is explained in the ES itself, identifying the off-site discharges into the respective catchment areas, alongside Stantec's analysis of the groundwater environment and spring flows to the protected sites. I've given you the references. It is in fact Dr. Clothes' conceptual site model, which is completely flawed, being based on the premise of aquicludes rather than aquifers. It's also premised on this entirely theoretical and fictional cross-sections, which are said to be based on Stantec's ground investigations. They are not so based. The lines extended by him do not reflect reality and are simply done to support a hypothesis that the springs to the east are only supported by river terrace deposits, when that's obviously not the case. The river terrace deposits are terminated by topography. And of course, the scientific data reveals that the river terrace deposits are seasonally dry. Dr. Clothes is saying that the springs are wet, so they must be supported by water from elsewhere and the solid geology. So the foundational stone of his theory of impact is fictional, fails to reflect the scientific data. To like effect, he claimed that the elevation of spring 5 at 15 metres is higher than the associated groundwater measurements. In fact, water levels hole 01 and W01 on the appeal site are generally above 15 metres AOD, demonstrating that spring erosion receives water from the solid geology as much as from the river terrace gravel. This comes in Dr. Clothes contradicting himself as evidence where the borehole data demonstrating that the river terrace deposits are dry in the summer months at the appeal site perimeter. The projection of the groundwater levels observed in those summer months against the geometry of the base of the river terrace deposits, whereas in fact it demonstrates there is not a continuous water table in the river terrace deposits in the summer months, which is the fictional hypothesis of Dr. Clothes' evidence. This basic fact is simply not reflected in the cross sections drawn. The 12th assertion was that the impacts to the springs off-site had been neglected when dealing with the response to Network Rail's response regarding extraction near the railway line. That was an obvious mischaracterisation. As Dr. Dewhurst pointed out, the document in question was dealing with Network Rail specific issues rather than addressing the springs. The effect of flows to the springs has been comprehensively addressed in response to the Council, who along with the EA Natural England have accepted the appellant's expert and scientific approach. Conclusions. The third assertion made by Dr. Clothes, 13th, I should say, assertion made by Dr. Clothes was a claimed impact on surface water flow path as a result of the screening bund to be constructed. But as explained by Dr. Dewhurst, whilst the bund will affect surface water flows in a potentially beneficial way, it will still allow water to infiltrate to the ground on the appeal site and to emerge as spring flow. The effect is therefore entirely beneficial and potentially reducing flooding nuisance from surface water flow in higher intensity events, but maintaining spring flows. The 14th assertion was to suggest that the drainage features proposed in the restore phase will be subject to engineered lining which would reduce flows to the spring. Again, that's simply wrong as a matter of fact. There are no proposals and no need to install such drainage liners of the type suggested. To the contrary, the intention is to allow the drainage features to drain into the natural ground, and the design is based on the infiltration rates accordingly. The attenuation ponds will act as the reservoirs, guarding against surface water flooding for such drainage to occur naturally through the drainage features, replacing and mimicking the existing aquifer storage provided by the river deposits. Any changes in the rate of infiltration will be material, let alone significant. The 15th comment was to refer to flow from the north under the railway line occurring in the solid geology as potentially affecting the extraction. As Dr. Dewhurst pointed out and was not challenged, any such backup of groundwater flow that may be occurring will be offset by discharge from springs 4, 5 and 6, which obviously already receive flow from this direction, and such strata as by the railway drainage, and this will not affect the extraction of the aggregate. The 16th assertion or criticism was in relation to sections 8 and 9 about the regulators. Section 8 is based on the same errors we've already identified, and section 9 was based on commentary on the letter from the Environment Agency and its adequacy, failed to address the letter in its context and to address the way in which all the regulators were satisfied with the further information and scientific work done. Section 10 of Dr. Clothier's evidence similarly repeats those misconceived assertions identified previously. Dr. Dewhurst summarises the position in her rebuttal. The allegation of a failure to rule out any likely significant effect is completely unsustainable. The flow of groundwater from the appeal site is simply insignificant in and of itself in terms of quantities of fresh water of the river and the national network sites, draining large catchments and being tidal in an event. Tiny quantity of fresh water from the spring flows, even if it were to be materially effective, which is not the case. Even if one ignored the twice daily effects of the tides, could simply not have any likely significant effect on these sites. The allegation of any oversimplification of the baseline regarding the hydrology of the streams is manifestly wrong. It's Dr. Clothier's baseline which is flawed by the most basic errors. By contrast, the appellant and its experts have conducted an extremely thorough assessment of the baseline and established that any impacts on the springs, even if they were to arise, would be insignificant. So further monitoring the streams is completely unnecessary in light of the extensive hydrological investigations that are already taking place, which demonstrate by the ground investigations and the hydrograph very limited effects of groundwater in the river terrace deposits on the springs. The allegation of a likely impact on stream hydrology during the extraction of gravel is without any foundation. It was based on Dr. Clothier's mistaken understanding of stage extraction and dewatering. The allegation of impact on stream hydrology in the restored state is completely misconceived in light of the restoration plan that will mimic the existing drainage arrangements in circumstances where full accounts being taken of the inert fill, consequential infiltration rates, and the designed attenuation infiltration measures that will ensure the mimicked flows. Any notional change to the hydrograph of flows to the spring will be immaterial in effect, as Dr. Dewhurst identified. It's completely unnecessary to suggest that one needs to have such a hydrograph presented to demonstrate that. The allegation of fundamental changes to hydrology or permanent and irreversible changes simply flies in the face of the evidence. I then turn to the second assertion, which would need to be true. Even if, contrary to all the scientific data and expertise presented, there were any likelihood of some material effect on the springs in the appeal scheme, contrary to what we said, that would not mean there was any likely significant network sites anyway. So Dr. Clothier asserted that any changes may affect the supporting habitat of the surrounding designated sites. He doesn't put forward any evidence to support that. Instead, he left that issue to Mr. Andrews, but Mr. Andrews' evidence plainly didn't identify any likely significant effects either. As identified by Dr. Dewhurst, the first and fundamental point is that the appeal site represents that less than 0.2% of the fresh water catchment feeding those water. That's a tiny area, and the 0.1% I've referred you to earlier from flow data. On that basis, Dr. Dewhurst is obviously right to note that even if the effect were to cause these springs to cease to flow altogether, which no one is suggesting, there would be no likely significant effect on the water bodies anyway, and no one's produced any evidence to suggest that it would. The experts of the appellant in the shadow HRA and the without prejudice addendum SHRA, the Council's own HRA, and of course Natural England are all clear that there are no such likely significant effects at all. That cannot be remotely surprising. We set out some text from the prejudice addendum, which I won't read out, but again, make clear that the salinity levels in the relevant water bodies are of such a scale that the dilution effect of fresh water is inconsequential. That's done by reference to PSU levels. So. In his evidence, Mr. De La Haye, responsible for the assessments, confirmed categorically the absence of any scientific doubt that any changes in the groundwater supply from the appeal site, even if they were to occur, would not have any likely significant effect on the sites. With those conclusions in mind, endorsed by Natural England, I turn to consider the purported points of concern in their proper context. First, Mr. Andrews confirmed categorically that it was not his case that there would be any likely significant effects, let alone adverse effects, but his proposition was that it had not been shown beyond reasonable scientific doubt that there would not be no likely significant effects. That's an important starting point, as Mr. Andrews and HPD are not putting forward positive evidence of such effects at all, simply seeking to question the conclusions already reached by others who have examined the position, including Natural England. Secondly, as is flawed in evidence, Mr. Andrews' summary of the relevant case law from Wyatt and his approach to the issue was subject to the very significant of the permission of the principle I've set out above, that you as the competent authority are not just entitled, but can be expected to give significant weight to the advice of Natural England as the body with the relevant expertise. Whilst you could disagree, you would have to have cogent reasons for doing so, and Mr. Andrews' evidence ignored that important principle. Third, as Mr. Andrews then agreed, the correspondence from Natural England in CD G10 to, I think it's 13, I don't know why G14 said, I think it's G10 to G13, establishes the following. Natural England had been consulted on the proposed development. Natural England had clearly scrutinised the proposed development and supporting material in terms of effects, hence their consultation responses. Contrary to the assertion made, there was no evidence to support the notion that Natural England had lack of time or lack of resources or lack of information in order to make a fully informed assessment and no likely significant effects. At no point have they suggested they needed more time or information, and if they had had any objection or concern, they would have identified it as they did in terms of air quality, for which objection was subsequently withdrawn. Natural England were then consulted on all the subsequent updates to the shadow HRA, and then the Council's own HRA was similarly satisfied with the conclusions as to the absence of likely significant effects. Natural England had therefore expressly advised the Council, and we're also now advising you as the Inspector, that there are no such likely significant effects and they have no objection to the proposed scheme. Natural England have clearly provided that position based on their scrutiny of the SHRA and the Council's HRA, reflecting their own views. Natural England is the expert national advisor responsible for each of these sites in issue, with a range of expertise available to them and are particularly well suited to make that judgment. In such circumstances, the notion that there's a burden of proof on the appellant work that is done is inapposite. To the contrary, there'd have to be cogent or compelling reasons for disagreeing now with that judgment, that the proposal will not have likely significant effects in terms of hydrology, and their endorsement of the shadow HRA and the Council's HRA assessment. Third, Mr. Andrews and HPG sought to raise an issue as to whether the proposed drainage and infiltration measures are mitigation measures inherent to the proposed development, which can be taken into account in assessing likely significant effects, or whether they're mitigation measures addressing the potential effects on the national network site, which would fall to be excluded from that first stage in light of people over wind, but then considered at the appropriate assessment stage. However, Mr. Andrews himself came to suggest this was not actually a material issue in substance, as even if one were to ignore those measures at the likely significant effect stage and only consider them as part of the appropriate assessment stage, one would inevitably reach the same conclusion. If such measures as embedded mitigation prevent any likely significant effects, they would necessarily ensure no adverse effect on integrity arising at the appropriate assessment stage. But Mr. Andrews is obviously wrong that such measures are not embedded mitigation. His only basis for suggesting that was the fact that the LFA referred to the HRA process when considering the drainage proposals. But as Mr. Andrews accepted in cross-examination, drainage measures for extraction and restoration are an essential part of the proposed development in any event. The project would and could not proceed without identifying such measures as part of the scheme, regardless of the HRA process. He also agreed it was clear that the LFA required the drainage proposals to mimic the existing situation on the appeal site for the purposes of dealing with flooding in the ordinary way. It's therefore absolutely clear that such mitigation is indeed incorporated into the design as a standard feature, irrespective of any effect on the protected sites, as per people over wind and eco-advocacy. This is therefore a classic case of embedded mitigation anyway. Mr. Andrews' allegation of a serious flaw in that respect is obviously wrong, but the point is academic in reality, given the same conclusion would necessarily be reached even if one were only to consider the position at the appropriate assessment stage, as demonstrated by the without prejudice addendum to the SHRA that's used to consider just that. Or turning to the purported possible effects now asserted by HPDU, there is a conspicuous lack of clarity in their evidence and certainly no reference to what was originally written to any conservation objectives. There's no challenge to the actual flows in question we've identified above. All that's tentatively suggested that there's a possible effect on nutrient dilution in terms of nitrogen deposition, salinity, and or fresh water for birds. Each of these asserted possibilities are completely misconceived for any or reasons. First, they're premised on a notion that there will be any material impact on flows that in turn would be material at the point of entry of the national network site, when in fact no such material impact can or would occur for the reasons set out above. There's absolutely no recognition of the evidence explored above as to the total amount of flows from those springs into the water bodies. The fact that any effect on flows from the field site would obviously be negligible, as there is no intention nor mechanism to prevent such flows, and the fact that flows are into tidal bodies that inundate twice a day, so rendering the notion of freshwater flows being material to the water bodies without any foundation. Second, so far as nitrogen deposition and eutrophication is concerned, the premise was flawed scientifically. Nitrogen deposition on affected habitat has nothing to do with dilution at all. The appeal scheme patently doesn't generate any additional nitrogen deposition itself. Such nitrogen deposition of nutrients that are going into the water will be unaffected by the proposed development, even if all flows from the springs were to cease. Nitrogen load is not affected by dilution. Mr. Andrews confirmed he was not pointing to any evidence to support that theory. And of course, such a theory is nonsensical, as it would mean the concerns about nutrients and nitrogen deposition could be addressed by diluting the effects of such nutrients and nitrogen deposition, which is clearly not the case. To the contrary, as Mr. de la Haye confirmed orally in his own expert work in this area, where the nutrients and nitrates are in fact contained in a greater amount of water, it actually further spreads their detrimental effects to larger areas, e.g. mudflats. So the purported concern is incoherent and unscientific, and it's little wonder that Natural England clearly didn't support it as a concern. As to salinity, the notion that the groundwater from these springs is capable of affecting the salinity of the water body in question is obviously wrong, as dealt with in the SHRA material, given the scale of the water bodies. In desperation, Mr. Andrews then purported to suggest there might be an effect on certain species, such as the lagoon shrimp or the starlight anemone. Sensibly, this formed no part of his written evidence, and it should have formed no part of his oral evidence. Such species are only associated with specific water body habitats of saline lagoons, which of course these springs do not flow into. The location for these fauna are identified in the relevant designations and are nowhere near where we are. This was the clearest example of clutching at straws, and again it's little wonder that Natural England see no substance in any of these concerns. As to freshwater availability, quite apart from the fact that the appeal scheme is incapable of having any effect on flows from the springs for those substantial times of the year when the river terrace deposits would be dry in any event, it's obvious there's no basis for any likely significant effect, and none's been identified. Even if birds were drinking fresh water from many of the springs, there's a vast catchment of water feeding into the water bodies, as evidence from the flows from the river Hamble that Dr. Dewhurst identified. So it's simply absurd to suggest there would or could be any effect on birds, which, as Mr. de la Haye identified, obviously have a vast area of mud to use with water if they need. Fifth, Mr. Andrews has purported to fasten upon an alleged error on the part of Natural England of Stantec as the precise location of Badman Creek in the Triple S High. But as Mr. de la Haye pointed out, there is no such error on the face of the documentation anyway. And of course, no one's been able to identify how this has any likely significant effect on the national network site in any event, which all of the same points above apply. Accordingly, it will be of no surprise that Mr. de la Haye was emphatic in his professional opinion that it was beyond reasonable scientific doubt that the proposed development will not have any likely significant effects on any of the protected sites in relation to hydrology whatsoever. That's a view shared by Natural England. There are no reasons, let alone compelling reasons, for disagreeing with their professional judgment in that respect. This is nothing more than an attempt to cast forensic rather than any real doubt. Very clear and obvious conclusions that have been reached. It's born out of objection to the scheme in principle rather than any scientific, empirical, or reasonable assessment of all the evidence and the techniques for extraction and restoration, which are there to ensure that the appeal scheme does indeed mimic the existing situation in terms of hydrology. Accordingly, we invite you to attach significant weight to our own expert assessment, that of Natural England and the Council, to dismiss any basis for objection advanced by HPDG on such fanciful grounds. As to recreational impacts, the assertion that there's been no proper assessment of recreational effects and there remains reasonable scientific doubt is what's contended. There is no substance to this complaint at all. The starting point for such assertion is the assessment work that's already been undertaken in the shadow HRA and without prejudice addendum, and the Council's HRA and Natural England's consultation response, endorsing the conclusions reached. The same points apply to the significant weight, or not just entitled, but expected to apply to those judgments. As for the absence of any adverse effect on the integrity in terms of recreation, and of course the need for cogent or compelling reasons for departing from that professional judgment. Both the appellant and the Council adopted a precautionary approach in this respect, recognising that the existing trespassing use of the appeal site and not ruling out the possibility of significant effects from recreational impacts from the impacts of displaced recreational activity, but then conducting an appropriate assessment which confirmed there would be no such adverse effects, with which Natural England agreed. So we refer you to section 7 of the shadow HRA, paragraph 7.3, 7.4, 7.6, but I'm not going to read them out because the text there. The detailed layout plans for the proposed development and the yellow text of the SRHA make clear what's always been the case, namely that the proposed permissive footpath is set within a generous landscape area for use. It's clear from the layout plan that no fencing is shown from the footpath landscape area, and the text of the SHRA dealing with the screen has always explained that. And again, I won't set it out, but just quoted the bit that was already in the SHRA. The conclusions in the SHRA were endorsed in the Council's own HRA and, of course, by Natural England in being satisfied with both. The same conclusions have now been further endorsed in the without prejudice addendum, and by Mr. De La Haye confirms the absence of any reasonable scientific doubt about adverse effects in this regard. HPD has sought to cast doubt on these clear and emphatic conclusions, but none of the criticisms stand up to scrutiny. Again, it was discovered that their own analysis was based upon fundamental misunderstandings of the development, which has had the unfortunate effect of misinforming the public and obviously tainting their evidence. So, for example, Mr. Andrews had proceeded on the basis that the permissive path is simply a 3-metre wide area constrained by a bundle on one side and a fence on another. The same fundamental error is repeated in the survey that HPD conducted, so seriously misinforming local residents about the nature of the proposed and the very substantial area of open space with a dedicated permissive footpath that will continue to be available throughout the whole period of operation, and the subsequent even greater area available after restoration. Notwithstanding such basic errors which make the criticisms inherently viable, I deal with each of the points further to show why they aren't. First, HPDG and Mr. Andrews failed to recognise the basic point that in the proposed development, that the development is not one which increases the residential population in the area. It's not introducing new recreational impacts of the type that would ordinarily be addressed through the payment of a tariff. The Solent strategy, it's actually the Solent recreation mitigation strategy. As no new residents are introduced. However, even in those cases, the Solent strategy is not one that seeks to prevent the introduction of new residential dwellings and residents to the area, but instead to fund management measures to ensure that residents use the national network site appropriately. As Mr. Andrews conceded in cross-examination, the Solent strategy is not about seeking to prevent new residents using the area, but in fact encouraging them to the coast and managing them in a responsible manner. There's absolutely nothing in the strategy that proceeds on the basis that people using the national network site for recreation results in adverse effects which can't be managed. It's all about managing measures rather than prevention. As Mr. Andrews accepted, none of that was addressed in his proof, which simply proceeds on the erroneous basis that there would be an adverse effect if people were displaced from the appeal site to the national network site. Mr. Andrews expressly agreed that even if people were in fact displaced to the coast for such recreational activity, Natural England's position has been that such activity can be managed through the funding of the measures identified. He accepted that this was further recognised in paragraph 2.112 of the Solent strategy, which expressly recognised the inevitability of people using the coast anyway. It's simply a question of ensuring they use it responsibly. That's also reflected in policy DM 11 of the Eastleigh local plan for development proposing to introduce new residents into the area. Accordingly, even at its highest, Mr. Andrews' concern is not one which could or would lead to any basis for refusing permission, as opposed to simply requiring measures of which existing residents would already be aware. So the basic starting point of concern is flawed. A proper analysis of the Solent strategy simply confirms why there are no reasons, let alone compelling reasons, for departing from Natural England's acceptance of the HRE conclusions in this case. Secondly, although criticising the professional judgments reached by the appellant's experts on the acceptability of the mitigation proposed to address any displacement, Mr. Andrews conceded the Natural England judgment and its analysis in the Solent strategy was itself evidence upon which the HRA can properly be based. Contrary to what he asserted in his written evidence, one can make legitimate judgments without the need to carry out surveys. He further agreed the Natural England as experts would have objected if they had considered any adverse effects would arise, and such judgments were legitimately made on the basis that Natural England was satisfied beyond reasonable scientific doubt as to the absence of adverse effects. Third, much of HPDG's case and Mr. Andrews' criticisms have been based on the absence of surveys and not relying on HPDG surveys. When questioned about that in cross-examination, he accepted as follows: if a survey were conducted locally about a proposal which people do not like here at Quarry, there is the potential for bias, conscious or unconscious. Secondly, as to the surveys relied upon by HPD, there was no way of knowing who answered and may have been affected by them. Thirdly, such surveys with the potential for bias would not be scientific. Fourthly, Natural England did not require surveys in order to make judgments. Fifthly, even if one could overcome the issue of bias, one still has to ask the right neutral and objective questions. In relation to the first survey, it did not present a fair picture, as it suggested the appeal site would no longer be available, which was not what's proposed. And in relation to the second survey, question 11 set out a question as to the limits on access based on a footpath constrained by abundant fence without the ability for a dog to roam, which again is not the case, though Mr. Andrews thought it was. He agreed that question 11 was not an accurate description. His own proof of evidence did not show the full extent of the public rights of way with which the permissive path proposed would connect in terms of linkages in and around Victoria Park. In light of the available areas and what was proposed, he agreed Natural England was entitled to be satisfied beyond reasonable scientific doubt through the exercise of their judgment that there would be no effects. Accepting this, of course, is necessarily accepting there cannot be any cogent or compelling reasons for dissenting from Natural England's assessment. And even if there were any residual adverse effect which needed to be addressed, logically this could and would have been addressed by a contribution. No such contribution is required by the Council or Natural England as they're satisfied it's unnecessary. In light of those answers and any proper analysis of what's on offer during operation then restoration, there's no basis for seeking to impugn or question the conclusions reached by the appellant's experts, the Council or Natural England of the absence of adverse effects, integrity of the national network site. The permissive path, landscape area and the connectivity with the wider area will obviously still provide for a huge recreation area for people currently using the appeal site. Not only that, the area in question will link up with vast areas of recreational space which can continue to be used, which do not require to go to the national network sites. But even if some people were to be displaced, there's absolutely nothing in the Solent strategy which suggests that this translates into an adverse effect on integrity. To the contrary, the funded mitigation measures are ones designed to encourage access, but with responsible use, which is precisely what would happen. In addition to all of these points, no one's ever provided, to adopt Mr. DeLay-Hayes' correct identification that for those residents currently using the appeal site who are in housing that's been built since the introduction of the Solent strategy, their presence has already been accounted for in contributions that would have occurred when the housing was granted. Furthermore, we defy anyone on a site visit to this locality not to be struck by the enviable range of existing recreational areas available for all residents which don't require the use of the national network sites. That's readily illustrated by the route map posted near the station itself and included in Mr. Andrews' evidence, the Hamble Peninsula trails, which show the extraordinary range of options. With the proposed development in place, this will now be supplemented by a further 2.1 kilometres of permissive path and significant hectareage of open space for public use, which will be maintained specifically for that purpose. This will increase the usability of the area for all users, rather than simply those who are prepared to trespass and have to cope with, for example, the lack of ready access in the northwest of the site. It will now be a managed area for recreation with specific dedicated links. The reality is that the proposed development is in fact likely to attract additional usage in that condition, though potentially reducing existing pressures elsewhere, as all people will be able to use it, not just those prepared to trespass. By the same token, it's simply fanciful to suggest people will not use that resource on their doorstep and use the national network site instead. As Ms. Pearman explained from her own investigation of the area, along with Mr. Hay, national network sites are inherently unattractive for dog walking anyway, given their nature, locality and tidal nature, quite apart from the guidance and measures which are there to encourage responsible use and to discourage disturbance to the birds. By contrast, the appeal scheme with its proposed permissive path landscape areas, coupled with areas like Victoria Park, which it immediately joins up with, provide a huge array of walking opportunities in circumstances where Victoria Park specifically encourages dog walking. We therefore strongly submit there's no substance to this objection. The Council, the appellant, the Natural England have carried out an objective assessment, not affected by misinformation about what's proposed or the risk of bias, conscious or unconscious, in terms of opposition to the mineral site. We've reached a well-reasoned, clear and obvious judgment. There can be no reasonable scientific doubt as to the absence of any adverse effects on the national network site, and the embedded mitigation addresses the potential displaced activity. Even if that displacement were to occur, such use of the coast is encouraged with the measures the Solent strategy has already introduced responsible use. Dealing briefly with conditions in Section 106 undertakings, substantive agreements reached on appropriate conditions and consequential obligations secured by this Section 106, I should say, it says agreement, should say undertaking. Council considers that clause 14.6 in the undertaking, which provides for the cessation of the management obligations on the grants for subsequent planning permission, to be unnecessary. That can't be right in principle. If planning permission were to be granted by the relevant local planning authority for future development of the appeal site or any part of it, any such planning permission would necessarily have to address any subsisting obligations and to address them as a matter of principle. If, having done so, there is a basis for granting planning permission on whatever terms are then considered to be acceptable to address those subsisting obligations, logically there would be no requirement for the obligations to continue under the Section 106 undertaking. Unless and until that happened, excuse me, the Section 106 undertaking secures the obligation for the 30-year period in any event. So just to add, in terms of the closing submissions you heard, likewise, the suggestion that inclusion of that clause is somehow fatal to the scheme is obviously wrong. As the Council itself has identified, they're just simply looking for you to express a view on whether provision is necessary. Of course, we've explained why it is for the reasons just identified. If it's not necessary, you can say so. And of course, this had been an issue, is also capable of being dealt with by condition. Planning balance. We commend the planning balance assessment made by Ms. Pearman in her evidence. Permission should be granted in accordance with the development plan. There are no material considerations indicating otherwise. But even if there were considered to be any residual harms, they would clearly be outweighed by the many planning benefits of the scheme Ms. Pearman has identified. We have no hesitation in inviting you to allow this appeal for this much needed extraction to occur with the consequential restoration of the site that will. It is vitally important that such mineral extraction, which ensures no unacceptable adverse impacts, is allowed to take place to deliver these minerals needed for the sustainable growth of the country. Thank you very much for listening. I apologise it's taken me some time to get through it all.
Okay, thank you for that, Mr. Strong. That concludes the closing submissions. There are a couple of little formal things that I just need to do before we just have a little chat about the unilateral undertaking and timescales beyond that. Firstly, we had a brief discussion when we met last week. It was last week regarding costs. I do need to formally come back to that as part of the appeal process. So I'm going to go around each of the advocates in turn to see if there's any instruction or desire from the council's perspective to seek an award of costs. I'll first start with the council. Ms Hawkes, do you have any desire or instruction to seek an award of costs?
Not at this stage, sir, but obviously with the absence of Guion Lewis KC, I may have to take further instructions.
All right, I'm not so sure I'm going to give you that opportunity because that is the last part of the agenda. So I'm going to take that as a no at this stage. Mr. Fulbrook, same question.
No, sir. Thank you.
Mr. Strachan?
No, sir.
Yeah, that concludes that part then. So in terms of any further oral submissions in terms of evidence, there's no further matters that I will take into account in oral submissions. That leaves a couple of matters regarding the unilateral undertaking. I did send an email out last week to suggest that the Rule 6 party would be given the opportunity to comment on that by the close on Monday. I think they've already commented in the large, and there may be other comments that they wish to make, which I will still remain until Monday. I want them to see by the close next Friday a track change version of the unilateral undertaking that shows the comments made by the Rule 6 party and the response by the appellant to those. And then I obviously want at that point the final signed version of the unilateral undertaking by the close next Friday. Similarly, from the council's perspective, I will be looking for a civil compliance schedule. There is the thorny issue of the relevant clause, and I forget the number now, but I have wrote it down, but we need to think about 14.6. It's not for me at this stage to make any comment regarding that, other than to say that there are some merits in the council and the Rule 6 party's concerns there. And I will say nothing more than that and leave it to your consideration next week. In the light of what you said also in the concluding part of your closing statements, Mr. Strawn, regarding the necessity for that clause in the 106, if indeed there are other opportunities that can deal with that, or other mechanisms in the planning system that can deal with that. I won't say any more than that. It's a matter for you to consider. I'm not giving any direction. That's not for me at this stage to do. But there clearly are concerns I think that you need to take into account, and it may be or may not be reflected in the council's civil compliance statement. That's a matter for the council to consider. But I'll say nothing more than that, just other than to say that you have a further week to think about it, and I'll leave it at that. When we started these closing submissions, you suggested that you might want to talk something else about timescales, Mr. Strawn?
Yes, it's just that we have received the comments from the Rule 6 party on the undertaking. We did respond to those already.
Today?
So you've already just indicated that the Rule 6 party could still have until Monday to submit. Well, I'm not objecting to that at all. It's just that if that is the case, then practically speaking, in order to then deal with any further comments that are made, provide those comments in relation to a track change. If there were to be any need to reflect any alterations in the undertaking in light of any further comments made, there's just a practical difficulty in then signing the undertaking, getting it certified by the council and to you by the Friday if we're only going to get the comments on Monday. That's the only. So all I was going to ask on our part is whether, if that timescale envisaging is going to take place, could we have until the following, I was going to say Wednesday of the following week.
I can cut you short on that because the answer is yes.
Oh, well, thank you.
To come back to the Rule 6 parties comment, I've not changed what I said today, has not changed from the email that I sent earlier this week regarding the timescale for the comments on behalf of the Rule 6 party. So that Monday date's always been fixed. The Friday date is an aspirational date. It's a matter for you, I think. I'm not going to do anything with that unilateral undertaking because of other commitments in the next 2 weeks. So therefore, I have no objection to that being submitted 2 weeks today in its final form. I understand some of the internal processes that will need to be gone through to deal with that. So I have no problem with that. And it doesn't prejudice anything that I'm going to do. nor in essence does it change the opportunity for the Rule 6 party to comment and give those opportunity to comment if they wish to comment any further to yourself by close of play on Monday. So it's not changed the ground rules that much. It's just been reasonable, I think, in terms of you having the opportunity to take comments on board and to complete the necessary signatures that need to be sought and obtained. So that's not an issue.
That's very helpful. So that was the timing issue I was going to raise. So you've addressed that.
I have some other commitments over the next few weeks that will mean that it's not immediately pressing in terms of the completion of that agreement. So that's that. All right. So what will happen in the next couple of weeks? The inquiry, other than the documents I referred to, which is a track change version of the unilateral undertaking and the final version of the unilateral undertaking, no more oral or verbal, no more verbal, oral, or if you want to call it, it's the same thing. Our written submissions will now be accepted other than those 2 documents. Once I've received those documents, the inquiry will be formally closed in writing. I will send a note out via the case officer to all parties, which can go on the appeal website, that at that particular point, the inquiry is then formally closed. So we'll close in writing once I've received that final version of the unilateral undertaking and the track change version of that document as well. But for the avoidance of any doubt, the Planning Inspectorate, in accordance with the procedures, will not accept any further written submissions to the inquiry at all, other than those 2 documents. Unless there's any further things that anybody wishes to say, and I'll start with the council. Is there anything that you want to say?
Thank you, sir. Yeah, just to confirm about the seal compliance statement, that the deadlines would be the same.
Yes.
So, yeah, thank you. Yeah, that's the only matter. Thank you, sir.
Yeah, I think it has to come in at the same time. Otherwise, you have to do something in advance of seeing the final version. So, not a problem. Mr. Fulbrook, anything else in the final things that we need to think about?
No, sir, nothing other than to thank you on behalf of the Rule 6 party for the way you've conducted this inquiry. So thank you very much. That's
my pleasure. And thank you to yourself as well for your helpful interjections and the manner in which you've conducted your business as well, Mr. Fulbrook. I appreciate that. Mr. Strawn, anything else that we need to be aware about? And finally,
I don't think so, sir. Although I'm obviously on my own. If anyone who's instructed me has any issues that they could tell me, will come on screen now. But all I was going to do was just echo the sentiments that Mr. Fulbrook expressed.
Thank you very much indeed. I appreciate that. And same comments apply to yourself as well, Mr. Strawn, as indeed it's applied to Mr. Lewis and to Ms. Kirby-Orts on behalf of the council. You have your unraised hand up, Ms. Kirby-Orts.
Yeah, it was to reiterate the same comments, and our thanks to you, sir, very much for the inquiry.
That's all right. I thank you for facilitating the manner in which you did. I thanked you last week. Your organisation has been absolutely excellent throughout this inquiry. And the same goes to all the people who've listened through various complex technical amounts of evidence over the last few weeks. It's not been easy. It's a very controversial appeal. I recognise that. But my thanks to the community has been very, I think what I'm looking for, they've been helpful and equally been patient listeners, which is something I requested at the beginning of the inquiry. And they have heard things that they don't necessarily agree with, but they've dealt with those in a sensible manner that's not disrupted any of the proceedings. So from my part, I do want to thank the community for the way they've conducted themselves during this inquiry, which is very emotive, and I recognise that. But it's been a credit to the locality, I think, in the way that they've gone about things. So that's the last thing I think that I need to say. So it's just about 6:10. At that particular point, other than me formally closing in writing, there is no further submissions of verbal or written evidence other than the 2 documents I've mentioned. And at that point, we will close, and the next correspondence from me will be the formal closure, which will come after the receipt of those documents. So thanks to everyone for their patience this afternoon. Thank you for their contributions, and have a pleasant weekend. Thank you.
Thank you, sir.
Thank you, sir.